Wait, please, your lordship. Lordship, I'd like to mention for listing lordship one leftover matter that is on 18/7. Till date, lordship, it was not listed in the hearing matter, lordship. I am on run, lordship. Let the matter come up on Monday, lordship.
1st August. Wednesday.
Yes, lordship.
Well, therefore listening of one BML, it was filing 16/7.
Motion item.
Motion mail. Tomorrow mail report is on time.
Monday.
Monday. Already.
So I'd like to mention regarding item number 58 of this list of. This matter was listed in motion column on 18/7, lordship, and the learned PP said, lordship, that Forgery was there. Accordingly, lordship fixed on 19, and on that day also the matter could not be heard, lordship, and again listed today. So technically, this matter was not heard. So may I pray, lordship, this matter will be taken up before rising, lordship.
I don't know.
58.
Okay.
Lordship, I beg to mention the listing, a regular bail application. Petitioner is behind the bar since
When have you filed?
Lordship, we have filed yesterday, but number total, lordship.
And then you have to wait till it will be automatically listed tomorrow or day after tomorrow. If it does not get listed, then you mention.
Another item is that, lordship, item number 40, lordship. There is a report called for, but I am told that that report is not received, lordship.
What report?
Lordship, it is regarding suspected beef, lordship. That one report is called for and.
You are on interim.
Lordship.
After that, Shri Alana's report was called for, my lord, Shri also not received.
Heard Mr. T. Talukdar. What's the?
Number.
Heard Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for production of up-to-date case diary, along with the report which was called for by this court on earlier occasion. The prayer is allowed. Let this case be listed again on 11th of August.
Interim may continue.
The interim order shall continue till next.
Lordship, another one prayer, lordship. Item number 62 is a hearing matter, lordship. Lordship, I am having some difficulties today. My daughter is ill, lordship. So some accommodation, lordship.
Heard Mr. R. Islam, learned counsel for the petitioner, who prays for an adjournment on the ground of his personal difficulty. The prayer is allowed.
Not 60.
No date. Registry will.
May I please, your lordship? Lordship, I beg to mention item number 46, lordship. Kindly adjourn for that. We have already taken the concern from the other party. Interim is there, lordship.
Heard Miss
N.A. Begum.
N.A. Begum, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty. She has submitted that she has informed the Learned Standing Council of Custom Department. You are there. Also heard Miss N. Kakoti, Learned Counsel for Customs Department, who does not have any objection to the said prayer. Hence, the prayer is allowed.
Kindly fix a date, lordship.
21 August.
27 August.
27th August.
Of license.
May I please, your lordship. Lordship, I beg to mention listing one, lordship, leftover matter on 17/7, lordship, till date not listed, lordship. Let me be listed on, lordship.
Which column? Motion.
Hearing, lordship. Hearing matter, lordship. BA, lordship.
13 August. 13th.
BA already is behind the bar, lordship. Maybe taken up on earlier, lordship, on next week, lordship, 30 or 29.
1st August.
Lordship.
1st August.
Lordship.
My lord, there was a matter which was posted after vacation. We mentioned it even last week also. It has not been listed. My lord, otherwise this matter will not take even more than my lord, 1 minute.
You want, your prayer is for listing, hearing matter.
For listing, my lord, on that traditional ground, my lord, that section 50, my lord. That ground, my lord, can it be tomorrow because next
No,
week I'm
no.
going to Arunachal, my lord, that is why.
When will you be returning from Arunachal?
My lord, 29th,
1st of August,
first of all.
1st.
Wait, let's have beg to mention a bail application, lordship. Lordship, the matter was listed for 3 times, but did not release lordship. Can you pick the matter on lordship Monday?
1st of August,
It's too long, lordship.
1st.
May please, your lordship. Respect of item number 69, lordship, the good council is not keeping all the.
Heard Mr.
Is
What?
it?
B,
Is it us?
PJ.
9, my lord, along with my lord, 42 also tag matter, my lord.
Item number?
42 of supplementary and
No, no.
69 of daily list. 69 of supplementary and 42 of daily list. 69 supplementary, 42 daily list.
Who is for 42? You, different council.
No, Mr. M. Chaudhary is, I don't know. He's leading me in this case.
And in item number 42?
Same.
Same council.
And visit us. His name is not in the cause list, but he's leading me in this case.
In item number 42?
42, his name is there. In 69, my name is there. His name is not.
Okay. In both item number 42 and 69, same order. Heard Mr. PJ Das, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr. M. Chaudhary. Conducting counsel for the petitioner, Mr. M. Chaudhary. The prayer is allowed. Let this case be listed 13th August.
I'm on interim, lordship.
The interim order shall continue till next date. Let it be on 13th.
13.
May I please, your lordship? Lordship, I beg to mention on bail application for motion, lordship.
When have you filed?
File 16/6, lordship.
Monday.
Another prayer, lordship, another bail application, lordship.
When have you filed?
It is for hearing column, lordship. It was last listed on 4/6/2004. 4/6.
4/6
25.
NDPS matter.
NDPS. Any date for next week?
8th August.
Lordship, any date?
8 August.
May I please, your lordship, is a listing of a criminal appeal along with an IA, lordship. on-
Criminal appeal, you have to mention before senior court.
Yeah, with this lordship, I would to mention item number 45 maybe as an today lordship. CD is received, student is out of station. Lordship. Daily list. Item number 45.
CD is there.
Yes.
Short date.
Next week and date, lordship.
Today. We'll take it up. No,
Senior is out of.
let him be out of station. You appear. When the matter is called, you appear.
It's not available with me.
We'll deal with the matter when the matter is called up. Prayer for adjournment rejected.
Wait, please, lordship, I'll like to mention for listing of a bail application for.
When have you filed?
Withdrawal.
Tomorrow.
Obliged.
Here, please, your lordship. Also, I'm praying for listing of a bail application. It was last listed on 18/7, but the matter could not be taken up due to paucity of time, lordship. Thereafter, matter has been.
NDPS matter.
No, lordship, 420 and 409. And lordship already decided the application of a co-accused, lordship. That is why it is this, it is doing listed before lordship.
1st August. 1/8.
Already lordship, 47.
1/8.
Would it be on Tuesday, lordship?
Or you may make your prayer before registry.
Registry, I have already approached, but.
Then wait till 1/8. Otherwise, it will not reach. We know how many cases are pending. Yes, next.
Lordship, listing for listing of a bail hearing, lordship. It was filed on 10 March. Since then, it is pending, lordship.
NDPS matter.
NDPS, lordship.
For-
Co-accused is already granted by you, lordship.
14th of August.
Lordship, and short date, lordship. Next week, any date, lordship. Next week, any date.
8th of August.
Maybe the lordship.
Lordship, I am making this prayer on behalf of Mr. N. Burua. I beg to mention item number 59 and 60.
Yes.
Mr. N. Burua is out of station years ahead. It may be adjourned for the day. Next week, Thursday, it may be fixed.
Otherwise, it will require some time.
Yeah, it will-
Only difficulties, it's been pending part heard since August last year.
So should I release it from? No, otherwise taking up criminal roster and then civil hearing matter.
That's
Sir, we are praying,
Yours.
my friend had agreed on 31st, can we make an attempt?
31st, it will, till I take this roster, it may not be possible. Unless my roster changes. Because we are unable to finish the list.
Had heard it, which is why I was insisting.
We are adjourning it for today without giving a date. Let the registry decide. On request of Mr. What is your name?
R.J. Das.
R.J. Das, Learned Counsel for
I am appearing on behalf of Mr. N. Burua.
appearing on behalf of Mr. N. Burua for adjournment. No, heard Mr. R.J. Das, Learned Counsel, appearing on behalf of N. Burua, who makes a prayer for adjournment on the ground of unavailability of Learned Counsel for the respondent, appellant, to which Mr. H. Deka, B.D. Deka, Learned Counsel for respondent number 2, does not raise any objection. Hence, the prayer is allowed. Registry to list this matter after 2 weeks on a date to be fixed by it.
So in that case, will your lordship like to relegate me to another bench? Really?
Yes. This case is released from part heard.
Can I pray for a listing?
Pray for?
A date.
No, you pray before registry.
Deeply obliged.
It is your lordship. Lordship, I beg to mention a criminal revision petition for order is your lordship.
Senior court.
It is. Lordship. Lordship for listing 1BA in hearing column. On the last occasion, it was left out.
8th of August.
We short date, Lordship. Already in jail in one.
All are in jail. We don't have, you have to wait till 8th of August or pray before registry.
My lord, the practicing advocate from the Idol bench, my lord. The poker games, my lord, yesterday lordship took up and today 2 matters are there, my lord. 3 and 66, my lord. He has also unfortunately been arrested, my lord. We filed it yesterday. Can it be taken up, my lord? At 2, my lord. Same case, my lord. Lordship dealt with it yesterday and today 2 matters are pending. 3 and 66. Motion, my lord. Mine will be motion also, my lord. Can it come and do, my lord? A practicing lawyer, my lord.
Now, when have you filed?
Yesterday, my lord. To be honest. Because police custody ended yesterday, my lord.
Okay, at 2.
So highly obliged.
Oh, it was item 63 from supplementary list.
May I please, your lordship? I would like to withdraw my bail petition. As
What is your name?
K. Alam.
Heard Mr. K. Alam, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. Learned Counsel for the petitioner prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Hello.
Daily list, most of the item number 1.
It is your plan.
Yes.
Now, my lord, I have given it. Is it? Yes, my lord. My lord, this is my case, my lord. Otherwise, my lord, LCR has also received, my lord, and they have also filed their objection. This is my case, my lord. 1 year 8 months.
Why
25.
it is listed in motion column?
My lord, that is for the registry to decide, my lord. But be that as it may, my lord, fact remains, my lord. They have also, this is the third time when this matter has been listed. They filed their objection. This is my case, my lord. 1 year, 8 months, 25 days. Out of 14, no witness has been examined till date. And even the ground of arrest is also cryptic.
Yes, cryptic means
Cryptic means
where is the ground of arrest?
ground of arrest which they have communicated, your lordship will find at page number 40. Page 40, in fact, is a notice under section 50. It says nothing why he was arrested, but the memorandum of arrest, page 41, it simply says, page 41 is the memorandum of arrest, my lord, may kindly. Because there is the same stereotype memorandum of arrest which the NCB serves upon each and every accused in all cases, my lord. Your lordship, on an earlier occasion, this honorable court had already gave a finding that this memorandum of arrest is cryptic, as it does not say which particular offence or under 8C he has committed. It simply throws some figure and some section.
Yes.
8C of the NDPS Act contemplates 14 different types of offences.
Yes.
And moreover, on the length of detention of the out of 14 witness, no witness has been examined 1 year, 8 months. and-
Yes, Miss Dekar. Since when you are behind the bars?
29/10/2023. That's that small piece of paper, my lord, which I have given, my lord.
Okay.
All details are there, my lord.
Yes, what is your submission? Yes.
Are
Okay. Let her go through the records. We'll take it up.
After 5-10 minutes, ma'am. That much we can accommodate, but I thought they will seek for adjournment.
It is your lordship. Yesterday, lordship was pleased to hear this matter. This is for the other accused. That's the Love Nirvana issue, my lord.
Item 3.
Item 3. Item number 66 also arising out of the same CD. Lordship may take up along with supplement.
Kesari is with me. Do. Yes. We'll hear at 2. He will require case diary.
It's the same issue, my lord. He's another of the my lord persons who are playing.
Three miso.
3 mesos. This is another meso. The room was not similar to yesterday's case. My lord.
Okay, let us hear it at 2
My-
together with
my-
other item.
My deeply obliged. 66 also at 4.
66 also at 2. Item number 5. $64 nalage mati boitia. 5. What is the next item? 4. Six.
Item 64 was supplementary list.
Wait, please, your lordship. Lordship, this is a regular bail application, lordship. Co-accused already been released on bail out of the same forwarding report, lordship, on last day. Last 19/7, lordship. This is the order, lordship. Here to petitioner is lordship, owner and cook of the Bismillah Hotel, lordship. Considering the length of detention, lordship, this
When were you arrested?
lordship arrested on 2/7/2025, lordship. 23 days today, lordship. Forwarding report, Lordship, will find on page 13, Lordship. Sorry, Lordship, it's a forwarding report on page 14, Lordship. Page 15, Lordship, will find the co-accused, Lordship. Mominul Haq has already granted bail, Lordship, by this court in motion stage, Lordship.
How many days you are behind the bars?
23 days. There is
Right.
17 days.
I pray for calling for but there's been perimeter.
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Azizul Talukdar and Safiqul Islam, who are detained behind the bars since 2/7/2025 within bracket for last 25 days in connection with Govardhana PS case number 68/2025 under section 13 of Assam Cattle Preservation Act 2021. Code para 3 from the bail application number 2263. Learned counsel for the petitioner has submitted that. Who is the owner?
Owner is Azizul, petitioner number 1,
That
Lordship.
petitioner number 1 is the owner of the hotel from where suspected beef meat was recovered. And petitioner number 2 is the
Cook of this.
cook of the said hotel. He submits that considering the fact that the suspected beef meat has already been seized and also considering the period of detention within bracket for 25 days,
23 days.
23 days, they may be allowed to go on bail. He also submits that in the meanwhile, this court has already released one co-accused on bail on 19/7/2025 in bail application number 2263/2025. On the other hand, learned additional public prosecutor has opposed the bail of the petitioner at this stage and has prayed for calling of the case diary. Code para 6. Code para 6. 30,000 with one surety of like amount.
Highly obliged. Obliged.
This accused person has been illegally detained in a case, PS case number 503, without providing the grounds of arrest. Firstly, Lordship, initially I was arrested in a case, PS 499. There I have obtained bail. While investigating, they found some empty ammunitions in my house. Therefore, under the Arms Act and other provisions, they arrested again. In that arrest, Lordship, no grounds for arrest was provided. And I am in custody for 44 days, Lordship.
Case diary would be required. Case diary.
Lordship, I need it.
Heard Mr. B.P. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. When?
Lordship, on 8th.
8th of August.
Lordship, 44 days already been there, Lordship. Dispute PS, Lordship.
They have to bring.
Cases are there, Lordship. Short date, Lordship. Because, Lordship, entire arrest is illegal.
Can it be brought earlier?
7, Lordship. 6.
6th of August.
Item 5. Replay.
Please, Your Lordship. Lordship, pending investigation, Lordship, case diary will be required.
Heard Mr. D. Medhi, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. let this case be listed on 13th of August,
After 15 Lordship, after 16th August.
19th of August.
Duly obliged.
Item 6. Mayor, please look, NDPS in between quantity, is there in the corresponding?
Heard Mr. N. Mahajan, learned counsel for the petitioner, also heard Mr. K.K. Das. Call for the case diary. When?
Lordship on.
14th August.
Item 7. Lordship, I have two items, Lordship. Item number 11 of the same FIR, Lordship. One is anticipatory bail, one is this bail application for two FIR indicted, Lordship. One is inside jail. Item number 11.
In item number 7, we are calling for case diary.
We are behind the bar, Lordship, for 20 days. May be interim be considered for Lordship. All the allegations are totally false, Lordship. No
That-
such incident. I just want to draw one point, Lordship. In the providing report at page 17, Lordship. Seven.
Yes.
At page 18, Lordship. During the search of the parlor, one of the girl was found in obscene condition with man in a inside room of the parlor. No such man, no other person was arrested in this case, Lordship. All these allegations are totally false, Lordship.
That we have to verify from case diary. Heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. When?
Well, short date, Lordship. We are since behind the bar for 4.
8th,
No allegation. Lordship.
8th of August.
Item 65 from supplementary list.
My lord, may kindly say FIR, page 10, my lord. Well, in the same FIR, my lord, the learned sessions of Kokrajhar itself has granted bail, my lord. And this is the bail.
Why have you come to this
Sir,
court?
No, actually, before granting bail, we have approached. So, my lord, my submission is this: I have been barred since.
Where is your rejection order?
Rejection order, lordship, may kindly see page 19.
What is the offense?
Offense, my lord, that is section 13. Other sections are available. And so far, section 13(1) of Assam cattle trespass, that is only null. Others are.
What is the allegation?
Allegation that some cattle meat was
Where
found.
is the FIR?
Yes, page 10, my lord.
Okay.
And the same person has lodged the FIR, which your lordship has granted bail. That case number is 58, my case number is 59. That is the difference. And I am since the bar since the 24 days, including today, my lord.
And co-accused has been,
Granted bail.
what
It
is the
order.
date of your arrest?
Same day, my lord, 1/7. And listen the FIR, and that is also mentioned in that order.
Comma. Heard Mr. M.U. Mahmood, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Manzoor Rahman, who has been detained behind the bars since 1/7/2024 in connection with Kokrajhar PS case number 159/2025 under section 61 within bracket 2/299/325 of BNS, read with section 13 within bracket 1 of Assam Cattle Preservation Act 2021. The gist of accusation in this case is that on 1/7/2025, one Arjun Kumar Das of Kokrajhar Police Station had lodged an FIR before the officer in charge of Kokrajhar Police Station, inter alia, alleging that on receipt of an information through reliable sources that Hotel Alif beef meats is being sold in contravention of the provisions of the Assam Cattle Preservation Act, a search was conducted in the said hotel. Stop. During search operation, 10 kgs of suspected cooked beef meat was recovered from there. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 23 days, and in the meanwhile, one of the co-accused has already been granted bail by the learned Sessions Judge Kokrajhar. He further submits that the suspected beef meat has already been seized, and under such circumstances, his further custodial detention may not be necessary. Stop. Hence, he prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has opposed the grant of bail at this stage and has prayed for calling of the case diary. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. The petitioner has been detained behind the bars for last 23 days, and considering the fact that the suspected beef meat has already been seized, as well as considering the nature of offence involved, this court is of opinion that the period of detention undergone by the petitioner is sufficient for subjecting him to any custodial interrogation if it was required. Stop. His further custodial detention does not appear to be necessary for fair completion of the investigation if the petitioner cooperates in the investigation. Stop. In view of above, the above-named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Kokrajhar, with following conditions 1 and 2. This bail application is accordingly disposed of.
So maybe item number 9.
Yes.
No, please, Lordship, the FIR pays Lordship 12 Lordship. The petitioner is the owner, Lordship.
Petitioner is the
Owner
of
of the vehicle, Lordship.
what is the offence?
Offense, Lordship, the driver has illegally loaded the IMF liquid, Lordship.
What is your submission?
The Lordship, the petitioner represented to, he filed a criminal petition, Lordship, for Zimmer of the vehicle, the case 15, Lordship. The Zimmer is allowed, Lordship. Only for apprehension, Lordship. Could not appear before the IO, Lordship. Only for the Lordship, the interim may be granted, Lordship, the I appear before the IO, Lordship. Lordship, case 21 is the tax invoice, Lordship.
Where is the FIR?
FIR page 12, Lordship.
What was found in the truck?
Track, Lord.
What was found? IMFL. In
Lord.
India. What is your submission that are you involved or not involved?
Lordship, the petition is not involved, Lordship. He is only loaded the Lordship, the some goods are loaded lordships, the page 21 lordship, the tax invoice lordship.
Yes, Mr. Das.
If you look into the FIR lordship, it shows that they could not be able to show any valid documents lordship. And it is from Arunachal lordship.
What was,
It liquor lordship.
Driver has.
how much?
It is.
The season list lordship, page 19 lordship, type to him.
Page 19.
No, what is your submission regarding the allegations?
Lordship, I have no knowledge lordship, the said, the suspected liquor lordship. I have only the loaded the lordship, page 21 lordship, tax invoice lordship.
But they could not show at that time. No. Moreover, his role can be ascertained at the city.
Let him appear.
They could have.
Third, Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Kasem Ali, who is apprehending his arrest in connection with Tejpur PS case number 719/2024 under section 303 within bracket 2/317 of BNS, read with section 53 within bracket small 1 and small within bracket small a of Assam Excise Act. The gist of accusation in this case is that on 6/12/2024, one Sharat Chandra Das had lodged an FIR before the officer in charge of Tejpur police station, inter alia, alleging that on receipt of an information through reliable sources regarding transportation of illegally smuggled Indian-made foreign liquor from Arunachal to Dimapur in a vehicle, a search team was constituted, and during search operation, the vehicle bearing registration number NL01AF6996 was intercepted. Stop. During search of the said vehicle, the Indian-made foreign liquor was recovered from there. Learned counsel for the petitioner has submitted that the petitioner is the registered owner of the vehicle and he is unaware about the contents. No, where is the tax invoice?
Page 21 lordship.
He is unaware about the fact that the Indian-made foreign liquor was transported in his vehicle. He only loaded the goods of which the tax invoice has been annexed at annexure 6 of the bail application. He further submits that in the meanwhile, the petitioner had approached this court by filing a criminal petition for seeking Jimma of the seized vehicle and by order dated 7/4/2025 passed in criminal petition number 236/2025. A coordinate bench of this court has granted Jimma of the seized vehicle to the petitioner. Now the petitioner apprehends that if he approach the police for seeking Jimma, he may be arrested. The petitioner submits that he is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Stop. Let the case diary be called for. Let this case be listed again on 14th, 23rd of August, 20th August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Tejpur PS case number 719/2025 and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with the aforesaid case, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. List accordingly.
Diplomas.
May I please, Your Honor? Your Honor, I have filed this application under 482 for grant of bail in respect of the petitioner. The affair is at page number 10, Your Lordship. Sorry, Your Honor, 11, Your Lordship. Your Honor, kindly come to the page number 16, Your Honor. The written FIR, handwritten FIR, Lordship.
Yes.
May I read out the FIR, Lordship?
What is your name?
Rohit Basfar, Lordship.
Rohit.
Yes.
Rohit Basfar.
Yes, Lordship. My name is not there in the FIR. Later on, it is revealed. The facts of the case is that, Your Lordship, there is a holy celebration at their area, and there was so many persons. That is, FIR was lodged on 15/3/2025. The incident took place on 15/3/2025, and during that period also, holy celebration was going on. And holy celebration is.
Okay.
Yeah, somehow the victim girl, somebody put colors on her, and that turned into a fight between the petitioner, some group of young people. And yes, I was there. Rohit Basfar was there. The petitioner was there, Your Lordship. If Your Honors kindly see the FIR, Lordship, at page number 18, Lordship, they have narrated the allegation in 4 different points. The 3 men used to bully and if it is Mrs. Nikita Das.
Where are you reading?
18, page number 18, Lordship, of my bail application.
Yes.
Yes. This is the main offense. The 3 men used to bully.
Who are those 3? What are the names?
Nikita Das.
No, the names of those 3 men.
There is no name in the FIR, Lordship.
Okay.
They don't know the name of the people. The 3 men used to bully and if it is Mrs. Nikita Das and Roni Sangma Das. They even threatened to beat them by calling reinforcement. They tried to sexually assault and grab in a.
Lordship, this is a clear appeal of the same kind of Lordship.
Yes.
Here she is working as a manager, is a woman, Lordship, aged about 30 years. There cannot be any charge against her for 143 trafficking or rape. At the best, even the contents of the FIR are taken to be.
There can be charges under 143.
Trafficking, Lordship, she is serving only working as a manager on, like the other 4 girls recovered. She is also working as a manager on.
Okay.
She is a poor lady, Lordship. We are ready to cooperate, Lordship. We will allow to appeal.
What is the?
But only that this beauty parlor is as also a brothel, whatever they found as. And the supply of a girls, etc. Those are totally false, Lordship. All the 4 girls, the beauticians, who are there, our employees, who are trainee beauticians, there, Lordship. We are ready to cooperate. We may be allowed to appeal for the IO, get our statement recorded, Lordship. And in the event of coming up any material in the city, Lordship will be applicable to Lordship. That may be considered.
What is your name?
Birkhansri. Doimari.
Bikhanshri Doimari. You are named in the FIR.
Yes, Lord. Accused number 2. I'm simply an employee, Lordship, looking after that management of the parlor, Lordship. Yes, page 14, Lordship, last part of the FIR.
Yes, Mr. Lal. Yeah, read that relevant portion of the
FIR.
last paragraph.
No, they have brought the allegations, Lordship. No doubt on that. They have brought the allegations.
Necessary would be necessary.
Simply,
No, that is your denial. But offense is, we will call for the case diary.
interim protection till that day. Till that day only.
You have to wait. Heard Mr. S.K. Poddar, learned counsel for the petitioner.
One is 3 years punishable, one is 5 years punishable.
But this one, 143 is there.
No way.
That we will verify.
If at all.
We will verify whether you are involved in procurement.
My liberty will.
No, you are now at liberty.
Please, anytime it may, they are searching me for.
Heard Mr. S.K. Poddar,
Some different losses.
learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Considering the nature of accusation made against the petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence call for the same. Let this.
Earlier, it was.
Oh, yes, case diary has already been called for. Let this case be listed on 8th.
The petitioner is a sub-inspector of Polasbury Police Station. He was suspended for an offence. But you would find a statement of allegation at page 22. 22, third paragraph. This is my offence. During inquiry, it is revealed that accident took place at Korukoti, Koropara under Koirabari PS, District Udalguri on 112. In connection with the same incident, Dhirendra Nath has also filed a charge sheet in the court of CGM Amingaon showing the place of occurrence as Polasbury. Lordship, this was a professional misconduct, Lordship, a departmental proceeding.
No, what you did.
Lordship, it is the allegation is that for an accident that took place in Udalguri, I filed a charge sheet at Kamrup showing the place of accident as at Polakbari. Now, in the same incident, an FIR has been filed saying that this was done to siphon of MSAT claim, Lord.
You are still serving.
I am still serving 56 years, Lordship. My defense, Lordship would find at page 26. 26, Lordship, I have so cause was given. Para 5, Lordship would find. Therefore, I further want to state that the entry of dated 1/12 was not recorded by me, and there was no any record written by me. 1/12 on 12, but the said T.H. Homeguard Topon Bhuya had made it by taking opportunity of 1 month time, and with his handwriting, he has made the GD entry and also arranged all the necessary documents and falsely made case. Therefore, I was not aware about the matter as the CD of the same was written by someone else due to my ill health.
Why are you apprehending your arrest now?
Now, Lordship, they have issued, Lordship would find at page 36, they have issued a 35 notice. At page 36, I have appeared before the police on 8th. CID, Lordship. On 8th, Lordship would find at page 36, I was directed to appear on 8th. Hence, you are directed to appear before me on 8/7. I have appeared and I have cooperated. Now they have again verbally called me tomorrow. Lordship, I will appear, but therefore, since there was no fresh notice, I am apprehending arrest, that's all. Otherwise, Lordship, I have suffered 2 times stroke, Lordship. My health is also not good.
Yes.
Yes, Lordship, 191 is the rioting section is there added, Lordship, and moreover, section 200, it is of punishment for non-treatment of victim. And Lordship, 209 is non-appearance in response to a proclamation under section 84 of BNSS. These sections are there, Lordship, and Assam,
I have appeared, Lordship.
Assam Police Act is also there, Lordship.
I'll appear tomorrow also, Lordship.
420 is there, Lordship. So I press for calling CD, Lordship. Allegations are serious. Rioting is also there.
No,
191.
No,
No,
but,
it is
but
not
that,
BNSS, it's IPC
Okay.
section. It's not BNSS.
Okay.
Also,
120B
offences,
is also there.
Lordship, 120B, 166 is false claim by giving false evidence. 167, 191 is giving false evidence. 192 is fabricating. 200 is using false evidence as true. All are below 7 years of it.
heard Mr. B.P. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Dhirendra Nath, who is apprehending his arrest in connection with CIDPS case number 7/2025, registered under section 120B/166A/167/191/200/209/210/420 of IPC, read with section 98. What is 98? Read with section 98 of the Assam Police Act. What is 98?
Lordship,
If you are not ready with 98, then I'll call for the case diary. You come prepared on the next day.
no, Lordship, I'll just. Lordship will give me 5 minutes. I'll just. Thank you.
When can you produce the case diary?
Lordship,
The gist of accusation in this case is that
11. 11.
on
Lordship, willful breach and negligence of rules, Lordship, 98.
on 29/8/2024. Where is the FIR?
Lordship, FIR page 34, Lordship, 33. 33.
On on 25/4/2025, one Ali Kumar Dusad, Inspector of Police, had lodged an FIR before the officer in charge of CID police station, inter alia, alleging that on the basis of an FIR, which was on the basis of an FIR lodged at Polasbari TOP on 1/12/2023 in respect of an accident which occurred on 24/1/2024, which occurred in in the Udalguri district, the petitioner is alleged to have filed the charge sheet. That is the accusation.
Yes, sir.
Filed the charge sheet illegally for getting wrongful gain in respect of a connected motor accident claims case. Stop. This is the gist.
Yes.
Learned counsel for the petitioner has submitted that the petitioner is a serving. You are under suspension now. Serving sub-inspector of police, and presently he is placed under suspension. He submits that after lodging of the aforesaid FIR, he had received notice under section 35 within bracket 3 of BNSS, whereby he was asked to appear before the investigating officer of the said case on 8/7/2025. Stop. It is submitted by learned counsel for the petitioner that the petitioner has accordingly appeared before the investigating officer and has cooperated in the investigation. Stop. However, the petitioner has now been telephonically asked to appear before the investigating officer again
25.
on 25/7/2025, that is tomorrow. Stop. Though the petitioner is ready, it is learned counsel for the petitioner submits that though the petitioner is ready to appear before the investigating officer tomorrow also, however, as this time no notice under section 35(3) was issued to him, he apprehends that as the case against the petitioner involves non-bailable offence, he may be arrested in connection with the aforesaid case. Therefore, he prays for allowing him to go on interim bail as he has been cooperating in the investigation. On the other hand, learned additional public prosecutor has submitted that considering the nature of accusation against the present petitioner, no interim protection should be granted to him at this stage, and case diary may be called for. Stop. Let the case diary be called for. List this matter again on 28/2025. Stop. However, considering the submissions made by learned counsel for the petitioner, that the petitioner has complied with the notice issued to him under section 35(3) of BNSS by appearing before the investigating officer on 8/7/2025, he is hereby directed to appear before the investigating officer of the CIDPS case number 7/2025 tomorrow again, as well tomorrow again. Stop. If he does so, in the event of his arrest, tomorrow again and cooperate in the investigation. Stop. If he does so, in the event of his arrest, in connection with the aforesaid case, before arrival of the case diary, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. with following conditions, number 1 and number 2. Lists accordingly.
May
May I please, your lordship? My senior Mr. SCKL is on legs, so kindly pass over the matter.
I am good today, my lord.
Today only, for the time being. Yes.
Even if Mr. Cal does not come, you are ready to do. Let him come.
Because, my lord, it is a case, my lord, where 47 BNSS was not followed. In second case, my lord, there is a categorically no date of arrest was mentioned. Magistrate has categorically stated you arrest so as on 12/12/2024 and produce on 17/1/2025.
Okay, we'll hear it.
Yes,
Let,
sir,
let
okay.
him, let him come.
There is husband of my lord, Honorable Justice Ujjwal, we have categorically say in my case, person take to the my lord, the High Court and release from the court. Is a female.
Yeah.
Even bail was not granted, my lord. He was allowed. Illegal, arrest is illegal. That is my.
After some time.
Yes, sir.
Item 15.
CD has not been received yet. May play the lordship. Lordship matter may be taken after some more.
CD is not there.
Commercial contribution.
It is pending. When can you produce the case diary? Third, Mr. What is your name? A.S. A.S. Chaudhary, learned counsel for the petitioner.
Now within jail more than 92 days. Commercial quantity 180 days. And it was sent back for application also. More than 92 days, he is not a fire mentioned accused.
But
It is a fire statement.
case diary would be necessary for.
Also the grounds of principle of ground of arrest was not also followed.
For that also case diary would be necessary.
So short date maybe.
S. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. When?
8th of August.
8th of August.
Item 16.
CD not to wildlife.
So AB क्यों हुआ से?
Wildlife.
The last occasion, this matter came up.
आते हुए बस bench और मानो. Yes.
This matter came up couple of days back, my lord. So CD was available on that day. On that day, Mr. Esdas took time. Perhaps, my lord, if they can inquire if CD is available, my lord, Esdas. So we took time, my lord.
You find out whether case diary is available.
This is wildlife case.
But then it's an Assam police investigated case. So
Lordship, I will take the instruction.
let me take after some.
Let him find out.
I plead your lordship, your lordship, the matter may be taken up after some time, your lordship.
Why?
Your lordship, my senior is on legs.
Who is your senior?
Mr. Kial.
Okay, let him
After
come.
5 minutes. After 5 minutes.
Huh?
65, lordship,
Connected matters.
connected 67.
Okay, let him come. We'll take it up.
How many?
Item 18.
Where the petitioner was arrested on 11/11/2018.
11/11? 18.
6 or 8 months, 13 days.
How many witnesses are there? 12 witnesses. How many have been examined? What is the contraband?
306.9 kg of ganja.
306.
0.9.
Your Lordship, the petitioner was caught red-handed while transporting.
Just a minute, let him submit. Yes, what is your submit?
For offence, something that from where this contraband was seized.
When this is the first time you're approaching this court or your earlier bill? In these 6 years, you have not approached High Court.
No. Because I have to
So where is the rejection order of the trial court?
that I have not.
That is required.
Not the record, else here. Staff. No,
No, that apparently you may have some advantage. But why the trial court rejected the prayer? Maybe 37 embargo. Okay, what is your submission?
Yes. There is a delay in the trial. Basically, on concession,
Okay, how many accused persons are there?
3 accused persons.
Where are other two? They are also behind bars.
One is behind the bar. No.
You don't know.
Yes. That's-
You don't know about other two. Okay. What is your submission?
Your Lordship, the contraband was received, like, he was caught red-handed, Your Lordship, while transporting the ganja. And Lordship, it is a commercial quantity.
Yes, but 6 years is too long a time. Why the trial is, when the charges were framed?
On 18/5/2023.
Yes, anything? Heard Mr.
Is that all?
A.Z. Ahmed, learned counsel for the petitioner. Also heard Ms.
Upadhyay, Your Lordship.
P. Upadhyay, learned counsel for NCB,
DRI, Your Lordship.
DRI. This application under section 483 of BNSS has been filed by the petitioner, namely Suresh Das, who has been detained behind the bars since 11/11/2018 within bracket for last 6 years, 8 months, 13 days in connection with NDPS case number 82/2019 under section 20B2C/29/23/8C of NDPS Act 1985. The gist of accusation in this case is that the Directorate of Revenue Intelligence had filed a complaint before the Court of Learned Session Judge, Kamrup Metro at Guwahati, inter alia, alleging that on receipt of an information through reliable sources that one 10-wheeler truck bearing registration number WB61D 9423 would be carrying huge quantity of ganja in a specially built cavity in the truck, in the said truck. Stop. The truck was coming from Tripura towards Guwahati when it was intercepted. On 11/11/2018, stop. During search operation of the said truck, 306.900 grams of suspected ganja was recovered from the said truck. Stop. Learned counsel for the petitioner, Mr. A.Z. Ahmed, has submitted that the petitioner has been languishing behind the bars since more than 6 years, 8 months. However, till date, only 7 out of 12 listed prosecution witnesses have been examined, and there is unlikelihood of early culmination of the trial. He submits that though the charges were framed against the present petitioner along with 2 other co-accused persons on 18/5/2023, however, the trial has not been progressing in expected manner. He submits that due to long incarceration of the petitioner, his fundamental rights guaranteed to him under Article 21 of the Constitution of India have been violated, and he submits that under such circumstances, the embargo of Section 37 of the NDPS Act is not applicable. You are citing any judgments? In support of his submissions, learned counsel for the petitioner has cited several rulings of the apex court. On the other hand, learned Ms. P. Upadhyay, learned counsel for NCB, has vehemently opposed the grant of bail to the petitioner on the ground that more than 306 kgs of ganja was recovered from conscious possession of the present petitioner. And as the quantity of ganja recovered is of commercial quantity, the embargo of Section 37 is applicable in this case. She also submits that already 7 witnesses have been examined by the trial court, and only 5 are remaining, which are likely to be examined very soon. Stop. He submits that considering the fact that the petitioner was caught red-handed with the suspected contraband, this is not a case where bail may be granted on the basis of prolonged incarceration only. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary, gone through the scanned copy of the records of NDPS case number 82/2019. Stop. Now, Donna, quote koribo lagibo. Quote from bail application number 329/2025. dated 6/3/2025. Court para 10/11. Well, 13. Next, in the instant case, the petitioner has been languishing behind the bars for more than 6 years, 8 months, and only 7 of the listed 12 prosecution witnesses have been examined. Court para 15, 16, 17. One lakh with two sureties of like amount. Seventeen অলপ changes কৰিব লাগিব, change কৰিলে।
19. Out of that item number 1, it was left over, my lord, she has now, she's willing to make that item 1, the first item, my lord. Because, my lord, I have a matter fixed in court number 40. That is why I was waiting since long, my lord. She has now prepared item 1, the first item.
Let the call matter be taken up. We'll take it up after this matter. Yes.
Yes, Lordship, this is my second time, Lordship. It was last.
Who is for the prosecution? Yes.
It was last rejected by Lordship, retired as Lordship. Nandi Lordship.
On what ground it was rejected?
Yes, Lordship. That time going to get better of Lordship. Page 36, Lordship. Oh. Relevant order. The Lawnett additional BP submit dates. All the witnesses in the case have been examined by the trial court, and as such petitioner may approach before the trial. Having heard Lawnett counsel for the parties and perusal of the case report, it reveals that SARS has been framed against the present petitioner and co-accused, namely so-and-so under section so-and-so. However, the co-accused was allowed to go on interim bail by the Lawnett trial court, but did not surrender after completion of the interim period. In view of the above aspects, as the co-accused is absent for a long time, petitioner may approach before the Lawnett trial court to split up the matter against the other accused person, and Lawnett trial court shall record the statement of accused. However, the period of bail is rejected at the suspense. Also, here in the present application, I am on behind 14%.
What is the date of your arrest?
Yes, Lordship. They have the more than 3 years, Lordship. Date of arrest 6/12/2021.
3 years.
3 years, 5 months, 16 days. Lordship, here my putting the main grounds I have taken, Lordship, is 31, Lordship. 32, 33, Lordship. Only on the ground that the ground of arrest were not communicated to the present petitioner at the time of arrest. So his initial arrest was initiated, was illegal, Lordship. So he's entitled to it.
How many witnesses have been examined?
Lordship, all the witnesses, that is why I directly referred.
All the witnesses have been examined.
Yeah.
And the case is pending at what stage?
Appearance for Arguma. Because the co-accused was not appearing because after getting the interim bail, he is not surrendered. So though the case could not proceed further.
As per direction of this court, have you appeared before
Yes,
the?
yes, Lord, I have also filed an speed up petition that was not yet disposed of.
Not clear from the records, Lordship.
And what is the evidence against you?
There might be some allegations, materials, Lordship, but independent witness, as per my knowledge, so far concerned, Lordship, they did not submit the photo. Lordship, I am on that footing that my initial errors were appreciated. So this fundamental rights was highlighted, Lordship, so he said that to pay. As per the recent judgment of honorable.
Yes, Mr. Sharma.
In that regard, Lordship, yesterday also, Lordship, our APP, yes, Loker had will submit a written argument also regarding the date of arrest, because it is prior to Bansal also, Lordship.
Oh,
So,
there do not.
Lordship, only fixating on the same date, it can be disposed of.
Lordship,
Otherwise, Lordship,
of
the
course, Bansal,
records are not very clear, Lordship, so what happened to the
Lordship,
state of trial?
prior to the.
Now, what is the status of trial? What happened to his split up?
Lordship, that is
Apply.
not clear from the records, Lordship.
Because the direction of this court is about 12 months ago.
Yes.
So in this 12 months, that split up petition has not yet been disposed of.
Yes. Like that.
We'll call for a report
Yes.
Sure.
and then we'll decide. Heard Mr. A.Z. Ahmed, learned counsel for the petitioner. Also heard Mr. D.P. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner has approached this court for the second time, as his earlier bail application was dismissed by a coordinate bench of this court. Where is that order of dismissal? Dismissed by a coordinate bench of this court on 29/8/2024 in bail application number 1559/2024. He submits that in pursuant to the directions of this court in the said dismissal order, the petitioner had applied before the trial court for splitting up of his case, as one of the co-accused has jumped the bail and therefore trial is not progressing. However, learned counsel for the petitioner submits that, however, his application for splitting up of the case is yet to be considered by the trial court. Stop. On the other hand, learned additional public prosecutor has submitted that the available scanned copy of the trial court records do not indicate regarding the current status of the trial and status of the application filed by the petitioner before the trial court. Stop. In view of above, let a report be called for from the trial court as regards the up-to-date status of the trial and also as to what has happened to the application filed by the petitioner before the trial court, praying for splitting up of his case. Stop. The report should reach this court before the next date fixed. Let this case be listed again on 11th of August. 11th of August. The registry to issue requisition for the same. 8th. Okay, 8th.
Binding item 1.
I will just keep that small piece of paper, my lord, which I have given detailing that the date of arrest and the number of days is in custody. Lordship has got that paper, my lord?
Yes.
Yes, my lord. This is my piece.
What is the submission?
They have stated that no witnesses have been examined till now, Lordship. Lordship, I want to point out some dates, Lordship. Several, her Lordship, final complaint filed on 22/4/24, Lordship.
Yes.
After that, Lordship, several dates were fixed for CC, consideration of charge, Lordship. But Lordship, several dates were passed for CC, but counsel for accused Jayed Khan was not available, Lordship. So Lordship may note some dates, Lordship, 8/7/24.
Be slow. Counsel for accused Jahid Khan.
Is reflected on record. I will flag my Lordship. I will flag my Lordship may note some dates, Lordship. 8/7/24. Then 5/8/24, Lordship. 19/8/24.
Yes.
38/24. Clearly reflected, advocate for Jayed Khan is found not available today. He stated that he engaged advocate, still advocate was not available. So Lordship charges could not be framed. So finally charges frame on 7/10/24. After that, Lordship, 2-3 dates were fixed for evidence. Now, Lordship, the case has been transferred, so no date has been fixed for evidence. So, Lordship, this is the status of the trial. And they were, Lordship, intentionally delaying the trial, Lordship. So, Lordship, I wanted to point out these things, Lordship. And Lordship, his bail was rejected recently on 28/5/25, Lordship, because contraband was recovered from him, Lordship. He was caught red-handed, and Lordship, at the time of his arrest, he accepted arrest memo, Lordship, and his signature was there. That is why his bail was rejected. Lordship, recently on 28/5/25.
Where is the rejection order?
They have annexed the order, Lordship.
42.
Page 42. He was caught red-handed at the time of his arrest, Lordship. He accepted arrest memo, Lordship. His signature was there, Lordship.
Yes.
Okay, this is my submission. I am placing the judgment, Lordship. Regarding section 50, I am placing one judgment of coordinate bench, Jitul Ali, Lordship, and one I have submitted Kasif, para number 15.
Kasim is already, all the coordinate benches have dealt with Kasim. Kasim is of no consequence when it comes to.
Para number? 30,
9.
what it says?
It says that the purpose of the NDPS Act is lordship. Okay, he was he got red-handed lordship, and lordship this is impacting the society lordship.
And what Jitulali says?
In Jitulali lordship, he accepted arrest memo lordship, and the arrest memo was specific to the to him lordship, and his signature was their lordship. So
No, whether grounds were mentioned or not.
no, the in section 15 of this bill, grounds of arrest was not mentioned in Jitulali case, but lordship he accepted arrest memo. That is why bail rejected lordship.
That Supreme Court has not. Suppose Supreme Court gives an interpretation to a provision and coordinate bench gives a different interpretation, which would be binding on this court. No, you counter that delay has been caused by you.
Absolutely. My lord, we'll just see the dates which he has given. 8/7 to 38, 1 month, 22 days. And what is the total delay? The date, if your lordship counts from the first day to the last day, it is 1 month, 22 days. From 8/7/24 to 38/24.
So even if that period is subtracted,
Even if that period is subtracted, even then it is 1 year, 7 months, no witness. Now, my lord,
no, suppose this period is subtracted.
then it is 1 month, 1 year, 1 year, 6 months, 2 days. Now, my lord, this delay is also attributable to the NCB, my lord. I'll say how.
Yes, how?
They engage advocate. The advocate correctly went and he was appearing in Amingaon court. The occurrence is within the jurisdiction of Kamrup Rural, and they filed charge sheet in Kamrup Metro. Then when the council has come to know that this is in the wrong forum, he made an application here, and then it was transferred to Kamrup, this Amingaon court. It is they chose the wrong forum to file a charge sheet. That is why now she has submitted correctly, my lord, that the case has been transferred from Metro to Rural.
Okay.
So the delay is on their count. This is one. Second, my lord, the arrest memo which they are relying on, my lord, two coordinate benches of this court have already held that this arrest memo will not stand the test of Behan Kumar and Sukaisto or Article 22. I'll just show straight on that, my lord, where it is being held, my lord. My lord, may kindly come to page number 56, para 16. This is a coordinate bench. The name of the accused here is page 56, my lord.
Yes.
Para 16, my lord.
Yes.
This is an order granting bail to another accused in some other case, my lord, by a coordinate bench of this court. It is evident from the memorandum of arrest issued to the accused petitioner that it mentions the recovery of the contraband and states that there is a prima facie case against the accused under section 8C, read with 22C and 29 of the NDPS Act. However, it is a fact that there is no specific mention or detailed description of the alleged offence committed by the accused petitioner. It is also an admitted position that section 8C of the NDPS Act encompasses various types of offences, in fact 14 types of offences. But the memorandum fails to specify which particular aspect or sub-offence under 8C is being invoked in the present case to attract the application of section 22C and 29. This is an observation regarding now, my lord, whether in this case the arrest memo is identical to the present arrest memo. Kindly turn to page number 62, my lord. What to what, preposition, conjunction, everything same, except the name and detail of the case. Same type of arrest memo. Your lordship may compare page 62 with page, the arrest memo of the present petitioner is at. What is it? Uh-huh. 41. 41 is the arrest memo of the present case. Your lordship may juxtapose page 41 with page 62. Absolutely same.
No, but it gives an indication as to from where the methamphetamine tablets.
Which one page?
Page 62.
Yes, but
That it is recovered from so-and-so vehicle. How you are connected with that vehicle?
page 62 is not the arrest memo of the Eastern case.
Okay.
Page 62 is the arrest memo of a different case, the interpretation of which is at page number 56, para 16 just now, which I read.
Okay, okay. Where is the arrest memo of the
Present
case?
page 41, memorandum of arrest. May I read it, my lord?
Yes, first line gives an indication.
In consequence of connection with the recovery, my lord, because section 29 is there. What is the reason for my arrest? What I have done?
Okay. It is not recovered from your.
Nothing is said here. Whether recovered, not recovered, nothing is said.
Okay, heard Mr. M. Vishwas, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. This application under section 483 of BNSS 2023 has been filed by the petitioner Jayed Khan, who has been detained behind the bars since 29/10/2023, within bracket for last 1 year, 8 months, 25 days, 25 days, bracket close, in connection with NDPS case number 12/2025, corresponding to NCB crime number 18/2023 under section 21C and 29. You may take your seat. 29 of the NDPS Act, which is pending before the Court of Learned Session Judge Kamrup at Amingaon. The gist of accusation in this case is that on what is the date of filing of the on 22/4/2024, the NCB, the Narcotic Control Bureau, had filed a complaint, final complaint before the Court of Learned Sessions Judge / Special Judge Kamrup Metro at Guwahati, inter alia, alleging that on receipt of an information that on 28/10/2023, an information was received from reliable sources by the intelligence officer of NCB to the effect that a huge quantity of heroin would be transported from Manipur in a vehicle bearing registration number AS01A8182. Stop. Accordingly, a search operation was conducted, and during such operation, the aforesaid vehicle was intercepted. And how much contraband?
409 grams of heroin.
And 409 grams of suspected heroin was recovered from the secret cavity under the driver's seats of the aforesaid vehicle. Learned counsel for the petitioner has submitted that the petitioner was not for petition, nothing was recovered from the possession of the present petitioner. Recovery was,
Recovery was in the vehicle where the petitioner was there, man.
the vehicle belongs to you.
Vehicle, my lord, I've not made any such averment in my petition whether the vehicle belongs to me or not. My lord, I will deny, my lord, the vehicle doesn't belong to me. That is what the trial court will decide, my lord.
Okay, he was caught red in the law.
I'm saying that.
A line to continue. Learned counsel for the petitioner has submitted that though the petitioner was served with a copy of, with a notice under section 50. Where is the notice?
Page 40 is the notice, 41 is the memorandum.
Notice under section 50 of the CRPC when he was arrested, however, said notice does not contain any ground of arrest. Stop. He also submits that even in the memorandum of arrest, which was prepared when the petitioner was arrested, the basic facts which necessitated his arrest were not disclosed therein. Hence, he submits that there has been a violation of Article 22 within bracket 1 of the Constitution of India. And on that count, he is entitled to get bail. Stop. He further submits that the petitioner has been languishing behind the bars for last 1 year, 8 months and 25 days. However, till date, not even a single prosecution witness out of 14 listed prosecution witnesses have been examined. And it is unlikely that the trial would culminate soon. He therefore submits that the fundamental right of the petitioner guaranteed under Article 21 of the Constitution of India has been infringed due to his prolonged incarceration. And therefore, and under such circumstances, the embargo of Section 37 of the NDPS Act would be overridden. You are relying on any judgment? Okay.
Ravi Prakash and this.
Learned counsel for the petitioner has cited rulings of the apex, various rulings of the apex court in support of his submissions. On the other hand, learned counsel for NCB, Ms. M. Deka, has vehemently opposed the grant of bail to the present petitioner on the ground that the petitioner was caught red-handed with the seized contraband. She also submits that seize contraband, which is 409, how much?
09 grams.
409 grams of heroin is of commercial quantity, and therefore the embargo of section 37 is applicable to this case. She submits that in the notice served on the, in the notice served on the petitioner under section 50 of the CRPC, specific grounds of arrest were not mentioned. However, in the arrest memo, there has been clear indication as to why the petitioner was arrested in connection with the aforesaid case. And on the arrest memo, the petitioner has put his signatures also, acknowledging that he had received the said arrest memo at the time of his arrest. She submits that this is sufficient to comply with the mandate of Article 22 within bracket 1 of the Constitution of India. Stop. Next para. She further, learned counsel for the NCB further submits that the petitioner is not entitled to get benefit of prolonged incarceration in this case, as it is due to the conduct of the present petitioner, the trial got delayed. She submits that on 4 specific dates, that is 8/7/2024, 5/8/2024, 19/8/2024, and 30/8/2024, when the case was fixed for consideration of charges, the present petitioner took adjournment on the ground that his counsel was not there before the trial court on the said dates. She submits that as the trial got delayed due to the fault of the present petitioner, he may not be given benefit of bail on the ground of prolonged incarceration. Stop. In response to the submissions made by learned counsel for the NCB, learned counsel for the petitioner has submitted that even if it is accepted that the trial got delayed due to absence of the counsel of the petitioner on the dates when the case was fixed for consideration of charges before the trial court, the said period comes to how many days?
52 days.
52 days, that is 52 days. And even if the said period is deducted from the total period of incarceration undergone by the petitioner, still he would be treated, still it would come to 1 year, 6 months.
More than 1 year and 6 months.
More than 1 year and 6 months, which he submits that is long enough to get benefit of the prolonged incarceration for getting bail. Stop. I have considered the submissions made by learned counsel for both sides, and have gone through the scanned copy of the records of NDPS case number 140/2024. You have to quote from bail application number 329/2025, dated 6/3/2025. Quote para 10, 11, 12. No, before that, let us first consider the plea of the petitioner, that he is plea of the learned counsel for the petitioner. And let us first consider the submissions made by learned counsel for the petitioner regarding entitlement of the petitioner to get bail on the ground of prolonged incarceration. Then quote 10, 11, 12, 13. Stop. In the instant case, on perusal of the scanned copy of the records, it appears that till date, not even a single witness, prosecution witness, has been examined. It also appears that the petitioner has been detained behind the bars for more than 1 year, 8 months. Stop. Even if we deduct the period for which delay was caused due to absence of the learned counsel for the petitioner before the trial court on the dates of consideration of charges, the said period would still be more than 1 year, 6 months, which in the considered opinion of this court is long enough, and such a long incarceration, in the considered opinion of this court, would infringe the fundamental rights of the petitioner guaranteed to him under Article 21 of the Constitution of India. And under such circumstances, the constitutional rights guaranteed under Article 21 of the Constitution of India would outweigh the fetters imposed under Section 37 within bracket 1 within bracket small b within bracket small Roman 2 of the NDPS Act 1985, and the petitioner would be entitled to get bail on the ground of prolonged incarceration only. Stop. As the petitioner has been found to be entitled to get bail on the ground of prolonged incarceration, this court is not inclined to discuss the plea of the petitioner as regards non-furnishing of the grounds of arrest to him when he was arrested in this case, as he has been already found to be entitled to get bail. Under the aforesaid, in view of the above discussion, the petitioner, namely Jayed Khan, is allowed to go on bail of ₹2 lakhs with 2 sureties of like amount, subject to conditions in 17, para 17 of the quoted judgment. Conditions like theirs. This bail application is accordingly disposed of.
That's little the higher side.
400 and plus
Gram.
is heroin is too much.
Lordship, my lord. Yeah, my lord. Lordship, kindly first taken an item number.
Let the record come. Kiman item number 13. Item number 13. Yes, which should I take?
Your Lordship, I kindly think first item number 14.
14 to
Yes,
the
my lord. I want
40.
to put something, my lord, important thing is that, my lord. Item number 14, my lord. Yeah. Now, he was arrested on 12/12/2024, my lord. But as per order, he was produced before the court, sworn arrest, my lord, in this case. He was produced before the court on 17/1/2025, my lord. Your Lordship, kindly peruse that order, my lord, particular order passed by this learned court below, my lord.
Where? Page?
Yes, my lord, coming, my lord. Look to, no. Lordship, kindly come directly to page number 53 of the petition. Yes, my lord. 16/1/2025, he was produced before the court, my lord. And my lord, your lordship, kindly come to the, my lord. Para 3, it is stated in the petition that accused Sakidul Islam was arrested on 12/12 in connection with the NCB crime number so and so, so and so. And interrogation, para, my lord, 7. That is important, my lord. Arrested accused Sakidul Haq, alias Mama, on 12/12 was not intimated to this court, and the accused was not produced before this court after his survey on production date. Meaning thereby, after 1 month, when I was shown arrest, I was produced before the learned court below. This is the order. And another thing is, my lord, I have verified the record. 47 notice, 48 notice, nothing has been available in the, my lord, case record. My humble submission before your lordship is that 47 and 48 was not complied to. Then, my lord, they filed and, my lord, objection, my lord. Here, my lord. Lordship, kindly come to the page 26, my lord. Affidavit on behalf of the respondent NCB, my lord. I will also got it, my lord. It was filed on 23rd April 2025.
Page number?
Page number here 26 mentioned, my lord. I do not know, my lord. That objection petition on behalf of the NCB.
Just.
It was filed on 23rd day of April 2025. First,
Yes.
Yes, my lord. I want to submit, my lord. Nothing has been recovered from me, my lord. I was.
Who are you? What is your name?
My name is Shakidul Haq.
Shakidul.
Yes. They said, I am, my lord, prospective receiver of the goods, my lord. Only on the basis of, my lord, co-accused statement. No monetary transaction took place. Nothing has been available, my lord. And, my lord, most important thing is that there is a severe analysis between me and Motiur Rahman, my lord. And Motiur Rahman is released on bail, my lord. I shall produce, my lord, later on, my lord. After going through this letter, my lord. Motiur Rahman is released on bail by this honorable, my lord. That Shakidul's own final charge sheet, drug, peddling, work, Shakidul during investigation, business Devasis stated the name.
Where are you reading?
Page, second page, my lord. That Kosik Sarkar's, my lord. Page number 26.
27.
27. And para 4. Have a look, got it?
Yes.
My lord. Of their, my lord, reply. Voluntary statement, Motiur also stated the statement. Shakidul Haq Mama is associate Motiur Rahman, saw in the illegal methamphetamine. He is the one of the receiver of 329. Devasis Paul said that he was going to Coastbear over his meta tablet. Motiur Rahman and Shakidul Rahman allies Mama, my lord. But in the, my lord, severe analysis, I was only contact with Motiur Rahman, my lord. Shakidul Haq along with Motiur Rahman, Rakesh Shaw, invited before fix the deal methamphetamine tablet. Later so and so, so and so, so and so, so and so, along with severe analysis shows the Shakidul and Mama 99 to cheat 47 Motiur Rahman with a period of so and so, so and so. He used to, it was not, Sexton said not appear, Sahidul did not appear office even after taking to record, implicit appearing NCB. He applied for anticipatory bail. Shakidul is offender. That contention and paragraph so and so, Shakidul, he was the one going to deliver his property. Here nowhere they mention
when I was arrested, because this is the reason. When they know that lower court, they have not produced, that is why within 24 hours, they have to produce the petitioner before the learned court below. I am going to the, my lord, constitution for them. And my first ground is that ground of arrest also not communicated. They are silent about in the affidavit. Your lordship, kindly come to the article 22.
Constitution.
Yes, ma'am. I'll quote this one.
Yes.
Article 22, subsection 2.
Yes.
Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time of necessary journey from the place of arrest to the court or magistrate. No such person shall be detained in the custody beyond the period within the magistrate. So that aspect of the matter, our High Court has passed an order, my lord. Kamal Doctor, my lord. I got an opposite to argue this matter.
This is applicable in case of shown arrest also.
Yes, my lord, this is shown arrest case. Yeah.
Mm.
I also produce now. This is shown arrest case. They have to produce when they shown arrest.
In shown arrest cases
Yes, my lord.
also.
This is shown arrest case, my lord. Here in the instance, I come to the background of the affair. Person was, my lord, arrested and he was released on bail. Subsequently, he was arrested when he was come out from the, my lord, jail. Subsequently, he was arrested, my lord, 3-4 cases, my lord. Then all cases court has said arrest is illegal and take the accused person to the Honorable High Court and allowed him go, my lord, from the court, my lord, without furnishing bail bond. May I read, my lord? Your lordship, kindly come to the page 521. Secondly, my lord. Para, my lord. Para not mentioned. Page, my lord, 521. Same, no?
Where is 521?
521.
First page, second page, third. You.
Yes, my lord. First page, second page, third page, fourth page, my lord. Secondly,
Which page you are?
secondly, when this court granted bail in Pasigat case number,
Where are you reading? First page or second page?
I am reading third page, my lord.
Third page.
Your lordship, I will go to this, my lord. I have given, my lord, because I think it is.
No, you read. You read. I will find out.
Secondly, this court granted bail Pasigat PS 56 2024.
Yes, last page.
This court was not informed that accused was wanted Basar PS case number, Itanagar PS case number. Even the judicial magistrate first class who had passed the consequential order on a failing brother was not informed Sri Tapan Datta was wanted in this case. It is stated in the affidavit that Tapan Datta was arrested by Pasigat police, Recreation Police, Basar Police Station outside the court 19/11/2024 at about 4 p.m. My time is important. When he was handed over to Basir Police Station, who in turn produced accused magistrate on 21/10/11/2024, which is again beyond 24 hours and 1911, arresting an accused person in a different court outside the court where is granted bail to the accused person. I am reading from my lord before that paragraph, my lord. There are 2-3 cases has been mentioned, my lord, where it is shown that they are not compliant. After Article 22, have a lordship got it, my lord? Before that paragraph, second page. Article 22 concept deal with the protection against the arrest and detention in certain cases. While clauses 1 to deal arrest, second by Article 22 with preventive detention with which the present case is not concerned. Clause 1 provide that no person who is arrested shall be detained in custody without being informed. That is my important. As soon as may be ground of arrest, nor shall be denied the right to consult and to defend by a legal practitioner's choice. Clause 2, which is relevant, provide that every person who is arrested, detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for journey from the place of arrest to the court magistrate. No such person shall be detained custody beyond the said period without the authority of a magistrate. The language of clause 2 made it abundantly clear that the requirement under the said clause is of mandatory nature, non-compliance of which will render the arrest.
Okay, your submission is that in this case, 22(2) has been violated.
22(2) also violated. Although 47 also violated.
22(1) is also violated, 2 is
2 is
also.
also violated.
Okay.
That is my submission. And co-accused is released on bail, my lord. It is a motive. This is the motive Roman bail order, my lord. In respect of ground of arrest. No, no motive.
Yes.
This is the ground, my lord. 47, 40, also can you tell that nothing is available. So considering this,
Lordship, here, Lordship.
When he was arrested,
Yes, I am coming, Lordship.
12/12/2024.
In item number 14, Lordship.
we are taking up item number 14 first.
14, Lordship. In this case, Lordship, 7 notices were issued to him, but he did not cooperate with the investigation. After that, Lordship, his name was shown in as absconder in the final charge sheet, Lordship. He did not cooperate with the investigation, Lordship. Several notices were issued to him. He approached before for AB, anticipatory bail before the Honorable Court, Lordship, and Honorable Justice Marshall and the Lordship Court directed him to surrender before the court, Lordship. After that, Lordship, he was arrested in item number 23, item number 13, Lordship. He arrested here in item number 13, Lordship. But item number 14, he did not cooperate with the investigation, Lordship. His name was shown as absconder, Lordship.
In item number 14, he was not arrested.
He could not cooperate with the investigation. His name is shown as absconder, and
No.
Lordship is the final complaint.
Okay. So in this case, when he was arrested?
In item number 13.
13, he was arrested.
Okay.
In 14, he was not even shown as arrested.
12, Lordship, 12.
No. Item number 13 is, what is the case number? NCB, special case number?
In my lord.
Item number 14.
NDPS case number, my lord, and NCB crime case number 2/2024.
In 14.
In 14, it is 14, no?
Oh,
Yes,
And in NDPS case number?
300. 2020,
300 of
2024.
24. And in item number 13?
Item number 13, my lord, NDPS case number, my lord, I think 9 happened.
77 of 25, Lord.
2020.
77/25. Now my query is, you are saying that the petitioner Sakedul Haq was arrested in connection with item number 13, that is 300. Item number 13. Yes.
Now I am arguing 14.
No, let me.
13, 14.
In 70, in NDPS, listen to my query. On 12/12/2024, he was arrested, according to you, in NDPS case number 77 of 2024. He was arrested. And in this case, he was shown as absconder in the final.
State Lordship, in item number 14, he was shown arrested.
He was shown arrested. When? On which date?
I couldn't go for the, I know this.
No, his submission is that he was, after he was being shown arrested in in NDPS case number 300, he was not produced before the magistrate within 24 hours. There was a delay of almost 17, almost more than a month. So that violates Article 22, Clause 2.
Yes, my lord.
And on that ground, he is seeking bail. What is your submission?
Dear Lordship, I am unaware of this Lordship that when he was arrested, Lordship.
No,
I know this much only, Lordship.
no, you have to know you are representing NCB because NCB has shown arrested.
Dear Lordship, in this case, I could not go through the.
And where is the arrest memo in this case?
Nothing is available. my
In
lord.
item number 14, maybe arrest memo is not there, Lordship. Arrest memo or section 40 is not there.
Why you are saying that you are detained behind the, you are arrested in for
Yes, my
item,
lord. That order has been reflected in that order, my lord.
Tonight.
trial court's order.
Yes, my lord. I'll code order, my lord.
Mm.
Case number 53.
Ah.
And anyway, my lord, the ground of arrest, nothing is available in the record, my lord. Date of arrest also not there. In the objection petition, they are not mentioned. They have to mention all these things. Because they know they have committed mistake. This is the finding of the magistrate.
No, where is the document on record which shows that you are arrested in connection with NDPS 300,
A second case, my lord.
14, in 14.
Nothing is available, my lord.
So you are not arrested.
My lord, but magistrate has said, my lord, this thing, 2004 was not as intimated to the court, accused is produced. And your lordship kindly go to the DR hearing, reply what they have said.
Yes. What is their?
Yes.
wha-
51, my lord. 51. Fifty-one, my lord. Annex 3. Your lordship kindly read this thing, my lord. A date of arrest 4/12 to his production date 12/12/2024. Annex 3. And he was not produced. Minister has said. Your lordship kindly peruse the record. Annex 3, page 51. Have a look at it.
Yes. But whether it indicates that he was arrested in connection with NCB crime number 9.
Yes, my lord, I may read, my lord. That, my lord, that with regard to that hate and gazette constantly, the seas were recovered from the possession of a case has been registered HC 29-5, Guwahati crime number 9 2000. The entire seizure procedures conducted. Thereafter accused, namely Nurses Office 67C, say, President of Talib on dated information received Sakidul Haq, Guwahati hotel time on approval authority, not involved. That on Iman, sorry, my lord. So tendered the statement. He had made involvement drugs. 12/12/2005 arrest memo dated. 12 ground of arrest was explained to him. His relative were arrested. That custodial interrogation Sakidul is crucial. And after that, the accused Sakidul was medically examined. This is the objection they filed, my lord. It was filed with the district and session just come with, my lord. And nothing is available in the record. Ground of arrest is not available. Nothing is, they said 12 arrested. Subsequently, here is the record.
Okay. And in 14, 13,
13, my lord, 47. CDR দেখালে। And CDR, my lord, only he is contacted with Motiar, my lord. And Alageva, and a particular night for my lord, kindly come to 13.
no, before you go to 13, let me dictate. Are you able to show the date of arrest?
To the record and flag my if I find anything, Lordship.
Okay. Mr. No. Argue about case number 13.
Yes, madam. Well, here in the instant case, he was arrested on 12/12/2024, my lord. My lord, your lordship kindly come to the my lord. Here is the my lord. Nothing monetary transaction took place with me, my lord. Only with CDR, one of the accused person name is mentioned, my lord. Now select.
This is in respect of a different case.
13 is different, 14 is different case.
Why both are tagged?
My lord, I do not take my lord, madam. I think they take my lord. I never take my lord.
No, Lordship.
Because I am my lord, newly counsel engaged with this man.
This can be dealt with separately.
Yes, my lord.
Has to be dealt with separately. Okay. In 13,
Yes, ma'am.
what is the
Yes, my
date of your arrest? 12, 12.
Date of arrest 12/12/2024, my lord. And your lord kindly come to the my lord. I have produced my lord that document, my lord. Annexure C, page 49, my lord. Notice under section 47 BNSS Act, my lord. Have you lordship got it?
Page number?
Page number 49, Annexure 6. It was filed by me on my lord 15 July 2025.
There is no page number 49.
Your lordship kindly look to the 15 July, the additional affidavit filed by me, my lord.
Additional affidavit. It is not there.
Yes, sir. I think Annexure 6 file. This is the document. 47.
Atul, additional affidavits filed.
16 July. This is the certified copy of this act. Annexure.
Page number 46 side the auction additional affidavit. Yes, what is this? You may argue.
Yes, madam. That is, madam, you are hereby informed that you are arrested in connection with seizure for the Metropolitan Fight NCB crime number 9/2020 for the contravention. Their case is non-bailable, so you will be produced before you may submit petition before the honorable court. Ground of arrest was not communicated to me, madam.
Why it mentions that methamphetamine tablets were seized.
That was not ground of arrest as per Bihan Kumar's husband. I am coming, my lord. That is the, my lord, reason for arrest, my lord.
Oh.
I'm coming, my lord. There's judgment, my lord. I read. I read, my lord.
Reason for arrest is to prevent you from manipulating witnesses.
I'm coming.
Those are reasons. Grounds why your arrest was, how you are involved in this case. In this case, there is an indication that methamphetamine tablets were recovered.
Recovered, my lord. And you are necessary for the custodial interrogation. You are necessary for that.
That is reason. That part is reason that your
That is why he is the ground for arrest, my lord. My lord. 415, that is available, man. And my lord, there are other ground also, man. 415.
415.
bail application number 415. So we have filed the second case now, first case.
No, this is 415.
It took a while.
Okay, what you do, you flag the flag, you also flag. You also flag. We will take it up at 2.
Yes, ma'am.
We'll continue.
No, yes, my lord, we are arguing now 20, item number 23.
No, don't argue amongst yourself.
Sorry, sorry.
You keep it for lunchtime.
Sorry, sorry. my lord.
You flag the relevant documents. We will continue at 2.
Yes, my lord. Yes, my lord. Yes. My lord.
Yes, you have found out. Could you find the date of arrest?
Lordship, I have flag marked, that green flag mark, Lordship. On 16/1/25, one petition was filed by the officer, Lordship.
No, on which date he was shown arrested?
It is not available on record, Lordship. But
On the order, it was reflected, my lord. And document.
There was no prayer for. What is this? What is this green flag?
it was filed for custodial interrogation, Lordship.
He was not arrested.
My lord, but in their petition, my lord, I have already shown your lordship that no, this is the second case to it.
Which case?
Yes, my lord, coming, my lord.
Which case, Mr. Chaudhary?
Is here the session of paper. Is number 53, my lord.
In BA application 427.
Yes, ma'am. 51, my lord, annex 3, my lord. I don't know, it was also. Oh, no, 53 doesn't. Yes, my lord, 53, my lord. 53, my lord. NDPS case number 300, 2024. 16/1/2025. Order. Yeah, para 7 categorically stated. Arrest of accused Sakidul Haq, Mama, on 12/12/2024 was not intimated to this court. The accused was not produced before the court after his production on production day.
No, he was arrested in connection with a different case.
Yes, my lord.
He was not arrested in connection with this case. Therefore, it was not intimated.
Then, my lord, your lordship kindly come to the, my lord, that document. Next, 51.
Yes, what is this?
My humble submission before your lordship is that, my lord, I have gone through the record, my lord, in both the cases, my lord. I found, my lord, 47, 48 document is not available in both the cases, my lord. I have found, my lord. And, my lord, list of document also not produced before the court, my lord. List of document. I have gone through the record, my lord, both the cases. Nothing is available. My
No,
lord.
in the first case, this case which we are taking up now,
Yes, my lord.
you were not arrested. You were shown as an absconder and you were produced before the court on the strength of production warrant.
My submission is something different, my lord. I have gone through both the record. If your lordship go to the scan copy, my lord, I don't know, my lord, hard copy I could found. That list of documents should be sent from the, my lord, landed court below, my lord. It was not sent the list of document. Nothing, because reason behind it. Just now I take the instruction, my lord. Some document has taken signature by NCB from the jail, inside the jail. Last, my lord, 15, 16, 30 days before, my lord. And nothing, even I have produced the certified copy, 47 document, that is also not available in the record, my lord.
No. In this case, you have to go through the record, both of you. And I have some queries, you answer those queries.
Yes, ma'am.
We are taking up next item now. In this case, to answer those queries, only then we will be able to
Yes, ma'am.
consider.
If we allowed 1 day time, I will produce lordship, I will submit order and
Yes.
1 day time. only.
Heard. Mr. N to item number 20. Item number 13. Heard Mr. N.N.B. Chaudhary, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. This application under section 483 of BNSS has been filed by the petitioner Sakedul Haq. You, in your bail application, you have mentioned that you are arrested on 16/1/25.
Yes, my lord, I have gone through that, my lord. It was the forwarding date. Today, morning, I got all these things, my lord. Earlier, I am not appearing, my lord.
Who has been detained behind the bars in connection with NDPS case number 300/2025 under section 22C/29. Learned counsel for mainly press for bail on the ground of violation of
47.
the constitutional mandate of the Article 22(1) of the Constitution of India, as well as non-furnishing of grounds of arrest at the time of his arrest. Stop. However, when a query was posed by the court to learned counsel for both the sides as to on which date the petitioner was arrested or shown to have been arrested in connection with NDPS case number 300/2024 arising out of NCB crime number 2/2025. Both the council prayed for some more time to answer to the said queries. You point out whether he was even arrested or not. He might not have been arrested. He was found in prison when the charge sheet was filed. So there was no need to arrest and production warrant was issued. What is the facts? About facts, both of you clarify. When?
My lord, give me 1 week time, my lord. Because, my lord, here is
Now you take 15 days.
Just 15 days. And my lord, your lordship called the LCR, my lord.
Up to that case record may be called for.
Up to that LCR called for, and this LCR may be kept, my lord. Because my humble submission before your lordship is that some blank cover signature has been taken.
The prayer is allowed.
21%.
The prayer is allowed. It also appears that an up-to-date scan copies of case record of NDPS case number 300/2024 would be necessary for consideration of the instant bail application. Hence, call for the scan copy of the said record. List this matter when? 19th August.
It will be, my lord, long time, my lord. Can it be, my lord, on, my lord, 7 August?
Okay, 7th of August.
That's fine.
7th of August.
Hariom.
And the second case? No, both cases are different cases.
Different cases.
Now, what is your submission in 415?
415, my lord.
Date of
And
arrest.
the section 47 is not available in the case record, my lord. So, my lord, he may be allowed to go on bail.
Yes.
Arrest memo is also not there, lordship. So lordship, 1 day time may be granted. Lordship may fix it on Monday. I will submit arrest memo and notice, lordship.
My
Sir,
humble submission was something different, my lord. If it is not in a case record, my lord, how can it will come, my lord? Seven months. Because I am repeatedly submitting some document, they have took the signature from the jail and CB, my lord.
no, let us see what she produces. Heard Mr. NNB Chaudhary, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB. In this case, the petitioner has sought bail, has prayed for bail mainly on the ground of non-furnishing of grounds of arrest to him at the time of his arrest. It is submitted by learned counsel for the petitioner that no notice under section 47 of the BNS was served on him at the time of his arrest. On the other hand, learned counsel for the NCB has prayed for some more time to what? In writing, you will submit to produce the arrest memo and the notice under section, copy of arrest memo and the notice under section 47 served on the petitioner at the time of his arrest, for which she seeks some time. Prayer is allowed. Let this case be listed on
July, my lord, last week of July. Because, my lord, nothing to document.
30 July.
Yes, ma'am.
Okay. 30 July.
I just listed item 2A, article 47, 56 and 57.
One by one, Matam. Item number 2 first. Yes. One item number.
Other serious matters are also there. And then.
Who are the counsels for other? Who want to argue first? Yes, Mr. Mahajan, you come.
My lord, with all
Item
this-
number?
Item number 37. Here, my lord, with all respect, my lord. First of all, possibly here, my lord, the cart has been put before the horse, my lord. Here, what has happened, my lord, with all respect, my lord, I'll be very cryptic, my lord. My lord, the sections of law attributed, my lord, with all respect, my lord.
All these cases relates to same. Yeah.
Sorry, my lord. Yeah, same. Here, my lord, 60-day period of offences, my lord. So far as I am concerned, my lord, prior to arrest, my lord, with all respect, my lord, I was called by the police, my lord, and I appeared twice, my lord.
What is the offense?
Offence is, my lord, regarding issuance of a fake certificates, my lord, appointment letters, my lord, to which I have got nothing to do, my lord. This present accused, my lord.
Where is the FIR?
Yes, my lord. The FIR comes at page, my lord, with all respect, my lord, 21, my lord. Page 21, my lord. May I just read it, my lord? With reference to the subject cited above, I have the honor to inform you that this office has received a copy of the letter so and so, my lord, above wherein it has been come to our attention that certain miscreants are circulating a fake letter with a false signature of the undersigned to various divisions under Water Resources Department. The letter, as above, is fraudulent, as the signature stated in that order is claimed to be done by me, which is not true, and pertains to the ongoing issue mentioned in the office earlier correspondence reference to above. In this regard, you are requested to look into the matter and also requesting you to register a case against the aforementioned letters and take appropriate action against the accused persons. Moreover, CID inquiry bearing number so and so is already registered against the contents of the said letter. My lord, so far as I am concerned, my lord, I have.
Oh, forging the signature.
Exactly.
No one has been named.
No one has been named.
Why you were arrested?
If
See,
he- yes, my
when you were arrested?
I was arrested on 16/6, my lord. I was arrested on 16/6.
For how many days you are now?
Today I am in 39 days, and all offences, my lord, attributed to the case, my lord, sections of law attributed are 60-day period offences, my lord. And I appeared twice, my lord. Lordship would kindly have a look at page 6, para 5, my lord. I'll be very cryptic, my lord. There are petitions, may I, my lord?
Yes. Yes.
6th line, my lord. Ulubari, Assam, he has interrogated in connection with CID police station case number 4 on 14/6, my lord. The statement of the petitioner was recorded on 14/6/25 and he was allowed to go on PR bond by police. On 16/6/16, the petitioner once again got a call from CID police and he appeared, and thereafter, my lord, he was arrested, my lord. The reason being, my lord, the prime accused, my lord, I should not name him, my lord, he is there, my lord. What has happened, my lord, I was having a friendly relationship with him, my lord.
What is the name?
Abu Hanif, of course, who is prime or not, I do not know. That will be disastrous, my lord, because some other counsel is appearing for him, my lord. With all respect, my lord. Abu Hanif, I had a friendly relationship, my lord, at one point of time, my lord. Thereafter, it showed, my lord, because he borrowed money from me and returned in parts, did not return the whole. I have got nothing to do with the fake appointment letters, my lord. The monetary transaction between him and me, my lord, has been continuing prior to the from a date which is prior to the date of occurrence of this case, my lord. That has got nothing to do with this fake appointment letters, my lord. I never received any money from any person in the name of giving appointment, my lord. This is our case, my lord. I should not have been possibly arrested, my lord.
What is the ground of your arrest?
Ground of arrest, my lord, that I am coming to the forwarding report, my lord. With all respect, my lord. Forwarding report is that, my lord. 37, page 37, my lord. Page 37, my lord. Page 39, the averment which are against me, my lord, that I am pointing out, my lord. Page 39, 2, my lord. Page 39, my lord, of this present application, my lord.
Yes.
From the statement of witnesses, it is unearthed that a sum of money was taken by him following a deal for master role job workers under Water Resources Department. My lord, it has got nothing to do from any persons, my lord, who got my appointment letters or whatever be it, my lord, but from Abu Hanif, because I was having a business relationship with Abu Hanif, my lord. And his mobile phone have been seized. These are the grounds, my lord. So seized on suspicion of containing. On suspicion, my lord. On the date of arrest, there is nothing specific against him. Thereafter, my lord, his interrogation in his custody is required to unearth his other associates in the crime. The third paragraph that is not in consonance with para 4, my lord, because on para 3 states, it has been arrested, my lord, seized upon only on suspicion, my lord.
Yes, Mr.
And there is no, my lord, another, can I just put another line, my lord, with all respect, my lord?
Yes.
Whatever transaction is there between me and Abu Hanif, my lord, it pertains to some other matters, my lord, and that has been happening on from dates which are prior to the date of occurrence of this case. That would show, my lord, that I never received any money for appointing people in, my lord, fake jobs.
What is the date of occurrence in this case?
The date of occurrence is, my lord, with all respect, my lord, date of occurrence is, my lord, he will be able to ascertain, because, my lord, with all respect, I would submit.
No, but you are submitting.
No, why I am submitting, my lord? We had a relationship with 4 or 5 years, my lord.
No, how you came to know when that fake letter was?
Why I am saying, my lord, the FIR is omnibus, because date of
FIR.
Date of FIR, yeah, but from prior to date of FIR, my lord. Date of FIR I am stating, my lord. With all respect, my lord.
10 to 25.
10 to 25, my lord, much prior to that, my lord. With all respect, if there is any monetary transaction, my lord. So that cannot relate to fake appointment letters, my lord. Money got through fake appointment letters, my lord.
But the alleged offense was committed much prior to lodging of the FIR. It is prior to
31/12, my lord. 31/12/24, my lord, because it was pursuant to an WPC, my lord. Fake letter is dated 31/12/24 that occurs at page 27, my lord. I'm sorry, my lord, page 24.
Okay. Yes, Mr. Parashar.
My lord, there is three category, my lord. One
No,
person-
let us deal one by one.
My lord, just because of the this, my lord, is same, my lord. One who, my lord, make it, my lord, fake appointment letter. Few persons circulated it. And in the name of giving the job, my lord, and the assurance giving the job, my lord, they have taken money from the, my lord, candidates. So in this case, my lord, there are several candidates, my lord, and there are some people who among the candidates become a leader and collected amount. Out of 10%, 10 candidates, one has collected amount and
To
given to
give,
someone.
to give it to.
Given it someone. Matlab, three categories. One who make that fake, that is not yet come to the light, matlab, but few persons are there who, matlab, collected amount from the agents and from the candidate also. And few persons are there, matlab, who are also they are the candidate and they are become the group leaders among the candidates and collected money from the candidates and given his money also. Now, this person, Zakaria Ahmed Malab, several persons with Abu Hanif who is one of the, yes, there are few veteran mastermen are there. Abu Hanif is one of them. And Zakaria Malab gave money to Abu Hanif. Zakaria collected money and give to Abu Hanif. There are 3-4 witnesses who directly stated that I am not taking the name, but one Malak stated that authorization Sakori Diar Namot Nijae Mu Arolak Toka Disile. Moi Abu Hanifok diu. That is a statement of the Zakaria. Now Abu Hanif, he also stated that Malak taking my name. Abu Hanif stated taking my name. Zakaria has collected money from several persons. And there are statements of the witnesses in 164 also. In 164, I have not found regarding Zakaria, but 164 statements. Those are against Zakaria also. But he also collected and to convince giving money, he has convinced several persons to give money. At once, people don't give money to 3 lakhs. Several persons he has convinced. Subsequently collected money and given to Abu Hanif. So for
Now, after 39 days, his custodial interrogation is necessary.
yes, 39 days,
I was taken to police custody for 10 days, my lord.
No,
he introduced some victims with Abu Hanif also and directly taken to.
he has a role. You are saying he has a. Now, whether his custodial interrogation is.
Custodial interrogation, my lord. In this case, now till now, several persons have been arrested and few are not yet arrested. Some have come with AB also and some has not yet come also, my lord. My lord, a racket is there, my lord. And who procured that fake appointment letter? That appointment letter was annexed in a writ petition in the High Court. Subsequent to that, my lord, it come to the light.
Why for seeking, why it was annexed in the writ petition?
Yes, my lord.
In the writ
That
petition,
came to
it
light
came
in
to
that-
light that
In that manner, it came to
the
light.
appointment letter is a
That's fake.
fake one.
Fake.
Okay.
Fake one, my lord. And that is circulated by
That we have
several
got
persons.
nothing to do, my lord.
That is circulated by several persons.
In that appointment letter, there are appointments given to list more than one.
They sending the name.
Whether that copy of that appointment letter is there in the.
They have annexed also, my lord, in the first case also in Zakaria.
Now, why are you objecting to bail?
bail, one thing is that, my lord, all the persons are not yet arrested. No, my lord, 3 persons are only arrested till now, my lord. Till now.
Okay.
4, 5.
Heard Mr.
6 persons still arrested, my lord. Others are behind the bar, my lord.
Heard Mr. B.K. Mahajan. I will require the case diary. Heard Mr. B.K. Mahajan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Jakaria Ahmed, who has been detained behind the bars since 16/6/2025 within bracket for last 39 days, 37 days.
39 days.
Blank rakhi দিব। In connection with CIDPS case number 4/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3/340 within bracket 2 of BNS. The gist of accusation in this case is that on 10/2/2025, one Bhaskar Jyoti Sharma had lodged an FIR before the Additional Director General of Police, Criminal Investigation Department, inter alia alleging that certain miscreants are circulating a fake letter with forged signatures of the first informant to various divisions under the Water Resource Department. Stop. It is also revealed from records that said fake letter pertains to appointment of muster roll workers, muster rolls / work charged employees under the Water Resource Department. Stop. Learned counsel for the petitioner has submitted that the petitioner is not named in the FIR and is in no way involved in the offence alleged in the FIR. He submits that before getting arrested in connection with the aforesaid case on
My lord, with all respect, my lord. Page 5. Para 6, my lord.
on 16th, when you were arrested?
I was arrested on 16/6, my lord.
On 16/6/2025, he was served with a notice under section 35(3) of the BNSS, and in pursuant to the said notice, he appeared before the investigating officer and have investigating officer on when you appeared
14/6, my lord.
on 14/6 and had cooperated in the investigation.
16/6.
However, 2 days thereafter, he was again called
Yes, my lord.
on
16/6.
again called by the investigating officer, and on that occasion he was arrested. Stop. At the time of arrest, he was informed that he had monetary transaction with one of the prime accused in this case, namely Abu Hanif. Stop. However, learned counsel for the petitioner submits that the Abu Hanif was an acquaintance of the petitioner, and they had monetary transaction on as the said Abu Hanif had taken loan from
Page 10, para 10, my lord.
where
Page 10 of my application, para 10, my lord.
had taken
Page 10, with all respect, my lord, paragraph 10,
had
my lord.
borrowed money from the petitioner. Stop. Learned counsel for the petitioner further submits that all the offences involved in the CID case number, CIDPS case number 4/2025 what is the maximum punishment?
7 years, madam.
Entails maximum punishment for 7 years only, and therefore he submits that the maximum period of detention for which the petitioner may be kept behind the bars during the period of investigation under section 487 of BNSS is 60 days only. Therefore, he submits that considering the progress made in the investigation and period of detention already undergone by the petitioner, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of CIDPS case number 4/2025 and has vehemently opposed the grant of bail to the petitioner on the ground that there are several persons involved in the racket of issuing fake appointment letter and collecting money on assurance of providing employment as master role worker / work charge employees in the water resource department. He submits that the present petitioner used to collect money. No, he submits that there is evidence on there are materials in the case diary to indicate that the present petitioner had also collected money from the prospective candidates and have paid the said money to prime accused Abu Hanif. He further submits that the fake appointment letter was also annexed. No, the investigation as regarding who had forged the appointment letter and forged the signatures of the chief engineer water resource department in the fake appointment letters is not yet completed. And if the petitioner is granted bail at this stage, it would hamper the investigation. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary which was produced by learned additional public prosecutor. Give me the case diary. Remaining I will dictate in chamber.
My lord,
after
my lord,
going.
my lord.
Next item. A series or next? 8 months. Yeah.
Your Lordship, here I was served twice this 35(3) notice, Lordship, and twice I complied also. But in a similar situated circumstance, Lordship, other has been arrested in the case. That is why I'm apprehending my arrest, Lordship.
This is anticipatory bail.
Yes. Anticipatory and I have.
No.
I have.
Where is 2? Item number 2. এটা তো bail hai.
Item item number 2.
Item number 2 is a bail application.
Dear Lordship, I was taken for 6 days police custody. I have neither issued any appointment letter, Lordship, nor am involved in any of the conspiracy, Lordship. Yes, and I had prior transaction with the Ranjan Pegu, Lordship.
With whom?
One Ranjan Pegu, Lordship. I had monetary, but that I had for last 5-6, more than 5-6 years, I had transaction, very, we had a very cordial relation. And that was the circumstance, Lordship. And because of that, I have been asked in the police station and detained and arrested. And thereafter, I suffered for 6 days police custody. Now it is 20 days, 20 days custody.
What is the date of your arrest?
My date of arrest is on 5th. I have been called in the police station, and on there I was arrested, Lordship. 5th of July, Lordship. That is my case, Lordship.
Heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shunti Das, who has been detained behind the bars since 5/7/2025 in connection with same case. The gist of accusation same as earlier. Learned counsel for the petitioner has submitted that the petitioner was having monetary business relationship with one Ranjan Pegu, and there used to be monetary transaction between both of them. However, on 5th of, what was the ground of arrest?
Ground of arrest is similar only, Lordship, but nothing
How-
specific against me. Page only to another entire record.
Where is the
Page 19, Lordship. Following grounds of arrest, page 19. Arrest of above named accused person. He has been arrested. Sufficient evidence of involvement, commission of offence of the crime in the instant case has been found from the statement of witness on that he has conspired and convinced with other accused persons and took money in the pretext of providing job under water resource department and had shared suspected false document.
last line কি আছে নে? However, on before your arrest, whether you were issued 35(3) notice, why you went to police station?
Called, it was called, given him information on it.
The learned counsel for the petitioner submits that the petitioner was called to the CID police station on 5th of July 2024-25, and when he went there, he was arrested on accusation that he has connived with other co-accused persons and took money on pretext of providing job to the prospective candidates in the water resource department of Assam stuff. Your submission, on the other hand, learned, Shunti is male or female? Okay. He also collected money. Agor submission to instead of Abu Hanif, write Ranjan Pegu. Remaining thing as it is. I'll dictate in chamber. Give the case ready. Next item. Item number 8.
Here, Lordship, in the secretary here, I have served 35-3 notice, twice Lordship. Now again, 29 also another date fixed Lordship. My apprehension in a similar situated case, Lordship, the person has been detained and arrested. That is why already my statement has been recorded.
Justice Home Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. This application under Section 482 of BNSS has been filed by the petitioner Karuna Gogoi, who is apprehending his arrest in connection with Agor case to Likhibo. The gist of accusation same. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offence alleged in the FIR. However, he had received notice under Section 35(3) of the BNSS on how many occasions?
2 occasions, Lordship, and 2 occasions I have visited also.
Two occasions. That is on which dates?
One on 4th July and thereafter, Lordship, another day.
That is on 4th July 2025 and on
Just give it. After in
stop. Now why are you apprehending?
again on 29th I was called.
Dash D. Learned counsel for the petitioner submits that the petitioner has been called again by the investigating officer of CIDPS case number 4/2025 on 29 July 2025. However, in the meanwhile, several persons have been arrested in connection with this case, and therefore the petitioner apprehends that if he now appears before the investigating officer, he may also be arrested. Stop. Learned counsel for the petitioner submits that the petitioner has cooperated in the investigation by appearing before the investigating officer on 2 occasions, and he is ready to continue to cooperate in the investigation, and therefore he prays that he may be allowed to go on anticipatory bail. On the other hand, Learned, what is the
On the same locality, Lordship. I also stay there, adjacent to these.
what? But he has, what evidence is there against him? Whether he has given money to Ranjan Pegu. What is your submission? If there is no material, we'll allow him to go on bail. On the other hand, Learned additional public prosecutor opposed the grant of anticipatory bail to the petitioner at this stage, as the investigation is going on and several accused persons are involved in this case. Stop. He has also produced the case diary of CIDPS case number 4/2025 before, which was called in connection with this case. I have considered the submissions made by Learned counsel for both the sides and have gone through the case diary. Stop. Okay, you flag it. We'll pass. Wait for some time. If there are materials on what materials are there, let me go through the case diary.
Ranjan Pegu we are the same locality, Lordship.
So,
Don't question, Lordship.
so there was some monetary transfer.
Not that, yes.
So don't speak. Let me find out from the case diary. Yes, next.
34. Wait, please, your lordship. Lordship, regular bail application, we have this petitioner 38 days in jail custody, lordship, forwarded on 17/6, lordship.
What is your submission?
My humble submission is the lordship, this case was lordship arise out of that read petition, lordship, fake appointment letter, lordship. Now suddenly they woke up and lordship, this inquiry was made, lordship, and case was registered. All except this section 3184 non-bailable offence.
Who are you?
I am Rina Bormon, lordship. Bromo.
Why you were arrested?
I was arrested, lordship, ground of arrest that is stated in type copy, lordship, in page 20, lordship will find. Common ground of arrest, no specific allegation, lordship, only say she is collecting money. How much from whom, that is not there. And even that, lordship, when she was taken to police custody for 3 days, lordship, the 35(3) notice has not been issued to her, lordship.
Okay. Yes.
Huh?
Okay, heard, Mr.
Why not specified in the forwarding report, lordship?
You require her further detention. Heard, Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Rina Brahma, who has been detained behind the bars since 17/6/2025, within bracket for last 39 days,
38 days, lordship.
38 days in connection with Agor case to likhebo. Gist of accusation same. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offence alleged in this case, and she has been languishing behind the bars for last 28 days.
38 days.
38 days. It is further submitted that the petitioner was also remanded to police custody for 3 days, beyond which no police remand was sought for. Learned counsel for the petitioner also submits that though the maximum punishment prescribed by law for the offences involved in this case is 7 years only. However, before her arrest, no notice under section 35 within bracket 3 of BNSS was given to her. She further, learned counsel for the petitioner further submits that the petitioner is ready to cooperate in the investigation, and considering her detention, she may be allowed to go on bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that the petitioner had collected money on pretext of giving job of master role worker / work charge employee to prospective candidates. He submits that the money collected by the present petitioner is in the tune of more than 60 lakhs. He further submits that the investigation is still going on and there are several accused persons involved in this case. He therefore prays for rejecting the prayer for bail of the petitioner. Stop. I have considered so and so in the chamber. Huh? Have. Okay. এক লাইন লিখি থৈ দিব। Learned additional public prosecutor has also submitted that statement of the five witnesses, five numbers of witnesses whose statement were recorded under section 183 of BNSS have made categorical statement implicating the present petitioner in the offence alleged in the FIR. Baki reserve.
Regarding recovery, whether anything recovered.
I will find out. I will find out.
Hello.
Item 35. Wait, please, Your Lordship, because petitioner is a grade 4 employee and working in the office of the district commissioner Nalbari, my lord.
Why are you apprehending arrest?
Because he was at paragraph 4, my lord. He was asked to come to the office of the CID on 16/6/2025 at 10 p.m. And here, when he asked what is the reason, then he said, my lord, this regarding this case. Therefore, he, my lord, took the certified copy of this FIR, then came to know, but his name is not there in the FIR. And my lord, he is not involved because this water resource department is in Guwahati and he is an employee of the district commissioner Nalbari. And he has not received any notice under section 35(3) of the BNSS, my lord. And my lord, he is ready to cooperate with the investigation if it is required, my lord. Therefore,
Heard Mr. Arch
Goswami.
Goswami, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Paresh Talukdar, who is apprehending his arrest in connection with so and so. Agor case to likhibo. Gist agor to likhibo. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offence alleged in the FIR. It is also submitted by learned counsel that the petitioner happens to be an employee of the office of the water district commission. District
Commissioner Nalbari.
of the water resource.
No, not water resource. District Commissioner, Deputy Commissioner.
Deputy Commissioner Nalbari.
Since 2008.
Since 2008. However, he has been telephonically
Asked to come to
telephonically asked by police to come to the office of the CID police station
on 16/6/2025.
on 16/6/2025. You defaulted.
I have not received any. Yes, I have not visited.
However, he did not go there in pursuant to the said request. Now he is apprehending that as he defaulted in obliging to the request made by the police, he may be apprehended in connection with the aforesaid case. Learned counsel for the petitioner further submits that the petitioner has not received any notice under section 35 within bracket 3 of BNSS, though the maximum punishment prescribed for the offence involved in this case is 7 years only, which requires issuance of notice under section 35(3) of BNSS. Stop. Learned. On the other hand, learned additional public prosecutor has produced the case diary of CIDPS case number 4/2025 and has submitted that there are some evidence against the petitioner collecting some documents from one of the prospective candidates. However, at this stage of the investigation, there is nothing to indicate that as to whether he took money or whether he had any role in forging the signature of the chief engineer, water resource department, or circulating of the fake appointment letter. Stop. Considering the submissions made by learned counsel for both the sides, I have considered the submission made by learned counsel for both sides and have gone through the case diary of CIDPS case number 4/2025. Considering the materials in the case diary against the petitioner at this stage of the investigation, this court is of opinion that if he cooperates in the investigation, his custodial detention may not be necessary for fair completion of the investigation of CIDPS case number 4/2025. Stop. In view of above, the above named petitioner is directed to appear before the investigating officer of CIDPS case number 4/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2. Send back the case diary. This anticipatory bail application is accordingly disposed of.
Item 46. Obliged, my lord.
Please, Your Lordship. I am arrested on 6/6/2024. Means I have completed 49 days in custody, and I am staying at jail still today. Then other co-accused, long Your Lordship, long time in staying at jail. Then other co-accused, Your Lordship, because I have completed 49 days in custody.
You can stay for 11 more days if you.
I am not the final accused person also. I am also not the.
What is your submission apart from
Yes,
period
sir.
of detention?
Directly collected from me, Your Lordship, that I have committed this offense. No anybody says.
What is your name?
My name is Abu Hanif, Your Lordship.
Abu Hanif.
Yes. But
Okay.
my name is not mentioned in this FIR, Your Lordship, and also all the sections are same. Reset against the accused person. They have a 7 years of imprisonment and 60 days is statutory period. All the sections are same. No any another sections added to me, Your Lordship.
Okay.
Yes, Lordship.
Yes.
I shall be faced to trial, Your Lordship.
Third,
Committed or not offense.
Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Abu Hanif Chaudhry, who has been detained behind the bars since 6/6/2025 within bracket for last 49 days in connection with Likhibo, gist Likhibo. Learned counsel for the petitioner has submitted that the petitioner is in no way connected with the offence alleged in the FIR. Stop. She submits that the petitioner has not been named in the FIR. She also submits that the petitioner has been languishing behind the bars since for last 49 days, and the maximum statutory period of detention for the offences involved in this case is 60 days under section 487 of BNS. She therefore submits that as the petitioner is ready to cooperate in the investigation, considering his period of detention, he may be allowed to go on bail. On the other hand, learned public prosecutor has vehemently opposed the grant of bail to the petitioner on the ground that present petitioner is one of the main culprit and in this case, and he has collected what is your submission? He has collected several lakhs of rupees from prospective candidates directly as well as through the co-accused Zakaria Ahmed. He further submits that the investigation is still going on as several accused persons are involved in this case. He also submits that the investigation as regards the forgery and circulating of the fake appointment letter has not progressed much, and therefore grant of bail to the petitioner at this stage would hamper the investigation. He therefore opposes the grant of bail to him. I have considered the Likhibo in the chamber. Wait. I'll consider. I'll go through the case diary and thereafter consider.
I am staying in jail, then long time. Then
If you repeat, then I will reject it now. Let me go through the case diary.
Item 56.
Six, my lord, here in fact, they are the victim lordship. Got telephonic call from the CID to APF.
A series of how many cases? Heard Miss T. Som, learned counsel for the petitioner. Also heard, why are you apprehending arrests? To whom you paid money? You have paid money.
Some of us, not all lordship, because it is a joint petition by all. Few of us.
No, how many petitioners are there?
Here, one 56, one name has to strike out.
Shunti Das.
Already honest. His name.
No, what is a submission?
That apart, lordship, police has called us to appear in the police station, and we are also willing to appear, lordship.
No, who are you? Who are you? You are victim.
Yes, lordship.
How you are victim?
Some of the way when in the name of.
You have paid money to somebody. How you are victim, I want to know. It will make my thing easier.
Yes, lordship.
To whom you have paid money?
For certain transaction we paid here to Sunti, that is a honest confession, Lordship. Few of us.
Shunti.
Nothing, Lordship. We are not connected to any circulation.
You are defending Shunti.
Lordship, okay, that has been paid, Lordship, for some purpose, Lordship. That is the only. And that apart, Lordship, no involvement in circulating, nor that you will definitely reveal, Lordship, our conduct, Lordship.
No, your submission has to be reflected. So your submission has to be clear. What is your stand?
My basic stand is, Lordship, my reason of apprehension is we all are called in the police station because no notice has been issued to us as of now. That is why we could not appear, Lordship, and these are all 7 years punishment, Lordship. Notice is as per September Kumar until notice under section 35(3) is mandatory, Lordship.
Heard Ms. T. What is your submission? They paid money to Ranjan Pego. Whether they are themselves candidates or they collected money for. Okay. Do you require their custodial interrogation? Heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely 1, 2, 3, 4, 5, and 6, who are apprehending their arrest in connection with so-and-so case. Learned counsel for the petitioner has submitted that out of the aforementioned above named petitioners, petitioner number 2, Shunti Das, has already been arrested, and therefore this anticipatory bail in respect of the said candidate, said petitioner, has become infructuous. She submits that the petitioners have received, have been called by the investigating officer of CIDPS case number, when you are called to appear in the police station on different dates, and which they have failed to appear before the investigating officer. So she submits that as they defaulted in appearing before the investigating officer, they are apprehending that they may be arrested if they appear before the investigating officer now. She also submits that the offences involved in this case entails maximum punishment of 7 years, which requires issuance of notice under section 35 within bracket 3 of BNSS. However, in this case, the petitioners have not received any notice. Stop. She also submits that the petitioners are ready to cooperate in the investigation and therefore prays that they may be allowed to go on anticipatory bail. On the other hand, learned additional public prosecutor has opposed the grant of bail to the petitioners at this stage as Baki Agor anticipatory bail or same submission again in chamber after going.
And 57 also, Lordship. might take
Same.
some-
Same. আগত এটা submission লিখি নিব. Learned additional public prosecutor also submitted that from the case diary it appears that the petitioners paid money to Ranjan Pegu for for getting appointment as master role / work charge employee in the water resource department. Last item number 57 heard Misty Som. আগৰ কেছটো নিচিনা petitioner নাম বেলেগ থাকিব. The submissions are same. Mr. Parashar, you give me the case diary.
Item 366 and production is item 1.
হয়, আপুনি যাব কিন্তু প্ৰিন্ট আউট পঠাই দিবচোন. এই কি শৰ্মা আছিলে অভিষেকৰ ৱাইফৰ প্ৰিন্ট আউটটো পঠাই দিয়ক কাৰোবাৰ হাতত. Yes, item number
Item number 3. This is similar to the petition which was submitted for Lordship yesterday.
Yes. Who are you?
I am also one of the person
Lalin Geta.
who was apprehended from the club in Nirvana Resort, my lord. I did not book a room there, my lord. Mr. Silo, who my learned senior represents today, my lord. He had a room in that resort, and I was invited by Mr. Silo to stay in the hotel since he had a room. And I had come here to source materials for my wife's shop. My wife has an automobile accessory shop in Luzon. I have given the trading license, my lord. I had come to source materials for that, and since he had a room there in the resort, like the person yesterday, Mr. Lalfakama Ramte, I had stayed in the resort. And my submissions yesterday, my lord, I would like to reiterate them, my lord, that the search and seizure was without any authority of law, as the FIR does not reflect any, my lord, authorization or warrant for the search or the seizure. My lord, secondly, these persons were not caught red-handed or anything to substantiate the allegations that there was any gambling operation. In this commission, my lord, there is one judgment if lordship may like to peruse. So 1982, my lord. 1983, 1 GLR, NOC 83.
What is this?
My lord, that seizure of any implements of betting will not be sufficient, my lord, for causing any conviction. It has to be, they have to be caught in the act.
Under which provision? Under 14 only.
My lord,
Under 14 of the Assam Games.
yes, my lord, this is under the
But
Assam Act.
but the case has been registered apart from 14 some
15, 16,
Assam Games and betting.
My lord.
What is 15? Even possession is also whether possession is a crime.
Possession, my lord, 6 says presumption. But possession, my lord, there, my lord, I have to invite someone to bet. There is no such allegation there. My lord, 14, 15, 16, and 17. My lord, 15 is whoever opens or keeps a betting house, my lord. Then 16 is whoever is found in a betting house by a magistrate or a police officer entering into the betting house under the provisions of section 7. So, my lord, to attract section 16, my lord, section 7 has to be satisfied first.
Section 7, they have, yes, yesterday,
Ma-
learned additional public prosecutor.
Is submitted, my lord, but the FIR does not reflect. FIR says on receipt of information, they're simply gone. But FIR does
No,
not.
if that authorization is there,
My lord, if it
is
there
it
on-
necessary to reflect it in the FIR? It is not necessary.
My lord, if it is there on the record.
Yes.
If it is there.
So I have to verify whether it was
If it is actually there on the date.
before that search was made.
Before or after.
Okay.
Because first of all, there has to be a warrant or an authorization.
So if there was a warrant before search was
Before.
made, then
My lord,
your submission goes.
then submission would go, my lord, but the fact would remain that 16 presupposes an authorization under 7.
Yes.
Then 17 is anyone who communicates information about the result of any betting. There is no allegation of that, my lord. There is no allegation.
Okay.
So, my lord, to sum up, my lord, 14 is who bets or invites. There is no allegation of that. 15 is who opens or keeps a betting house.
ठीक.
My lord, 15 is who opens or keeps a betting house. That allegation is also not against me or, my lord, against Mr. Lalte, for whom I appeared yesterday. My lord, section 16 is presumption as to whoever is found in a betting house. First of all, there has to be a betting house. And, my lord, there has to be a warrant under 7.
Okay.
Then 17, my lord, is anyone who communicates any information about the result of any betting. That allegation is also not true. So, in fact, my lord, none of these allegations under 14 to 17 are attracted in this case against the petition, as well as Mr. Ramki. And my lord,
And
my lord,
your role in offense under 143?
there is no allegation as such against me. I was simply saying that, and as was submitted yesterday, my lord, it was only against the management of the resort. In fact, there is no such allegation.
No, but if something is found in the
If something is found,
is found in the case diary that
my lord, then there might be, but
That-
there is nothing against me so far as 143 is concerned. There is no allegation, and in fact, I have verified from the relatives of the petitioners, both the petitioners. There was no such allegation.
okay.
143 is not attracted at all.
Yes, Mr. Sharma.
Also, there are other two petitioners, also we can hear them.
No, one by one. Otherwise, I get difficulty in chamber.
Our submission
It piles up.
our submission will be
You
the
have
same.
to be specific. There in a resort, some people were arrested. Some are employees. Someone is the husband of the employee. Some were the guests. Each have different role. You must have some material against each of them to continue their detention. So what is your submission against the present petitioner? Whether in the case diary, his submission yesterday was that though from 3 different rooms,
Yesterday was for a different petitioner. also.
one of the petitioner who stands in same footing as per his submission, that from 3 different rooms, articles which may be used in gambling were recovered.
Okay.
But whether from the room in which he was staying, any article was recovered, is there any evidence in the case diary, material in the case diary, which suggests that he sexually exploited the victim girl who was trafficked there?
Yes.
So that material has to be there. What is there in the against the present petitioner?
Firstly, Lordship, regarding the gambling part, Lordship has found the seizure list is there. Otherwise, Lordship, the main event regarding the gambling event, it was organized in the banquet hall, Lordship, as I have already pointed out. There are photographs in regard to that also, Lordship.
When it was organized?
On that day, Lordship, on the date of occurrence. And in the past also, it was organized as per the allegation of concern, Lordship, and they are investigating into it. But Lordship, because Lordship, as I have already pointed out, Lordship, all the 32 rooms were booked by a single person, Lordship, and for all the guests. So they were there for the purpose of gambling only, Lordship. And Lordship, there are WhatsApp chat, contact details, CBR analysis, everything is there, Lordship. It indicates that it was an organized event for the purpose of gambling itself. Because Lordship, I have already pointed out the chats where the money transaction was done. All the petitioners, Lordship, including these 4 petitioners in particular, Lordship, their account number are being investigated into. Both of their two account numbers are there, Lordship, of all the petitioners. All their account numbers are used for digital transfer of money. No cash was done, Lordship. It is all digital, Lordship. This is not so. This is a very sophisticated game, Lordship, and Lordship will also see the guest list. There, Lordship will find that all the guests are not only from Assam, Lordship, they are from out states also, Lordship.
Now, whether all guests were involved in gambling?
Only 4 are before your Lordship. That has to be investigated into, Lordship. This is a very nascent stage of investigation. And this is not some card game, Lordship.
But the articles which were used in gambling,
yes,
have already been seized.
Yes, it has been seized. But investigation has to be done, Lordship, because
No, for that, whether you require their custodial interrogation.
absolutely it is required, Lordship. Because twofold submission, Lordship. Firstly, before Lordship, the case diary was placed before your Lordship on 23rd, if I'm not wrong, Lordship. In the meantime, they were under interrogation, Lordship. The facts which have come up from their interrogation, that is not before your Lordship. Firstly, Lordship. And I have been told, Lordship, though I cannot state it on record, Lordship, that some very vital facts have come up, which requires investigation. That is not before your Lordship. Because the CD is...
Bring that facts before me.
Yes, Lordship will fix it after 10 days. I will bring 10 days. Investigation has to be done. This is not some, Lordship, card game.
And their role in 143 offence?
That is also been under investigation, Lordship, because the girl who have been apprehended, Lordship, she has stated that she was being supplied with other girls to different guests of the hotel. That is from the employees also, Lordship. So that also needs to be investigated. Straight, Lordship, this is a very initial stage of investigation, Lordship. To sum up, Lordship,
no, but at the initial stage itself, you should have some material.
Yeah, Lordship, I have placed the materials, Lordship. All materials are there, Lordship. It is not expected to complete the investigation in 10 days, Lordship. How can we finish the investigation, Lordship? Prima facie, Lordship, there are materials that gambling was being done in an organized manner. All the rooms were booked.
And
the bank digital money was
if you remove 143,
Lordship. Even then, Lordship, even then.
If you remove 143,
yes,
the
even then.
Case, all the offences are
yes.
less than 7 years.
Yes. Correct. So, Lordship, does it mean...
Then the severity of the offence
Lordship, but
is lesser.
Lordship will take a look from the materials that have been collected so far, Lordship. Does it not warrant an investigation, Lordship? Outside people said there.
No, my concern is whether it requires
absolutely
custodial interrogation.
It requires, Lordship. That is what I'm
if they cooperate.
Yes, so that is why, Lordship, I have submitted twofold argument. So one is, Lordship, the interrogation which has revealed certain new facts, Lordship. That is not before your Lordship. And I cannot state it off the record, firstly. And second, Lordship, the materials that are already available, does it not warrant further investigation?
When you
Lordship?
can produce those?
As your Lordship permits, Lordship, we can produce the case diary. It needs to be updated, Lordship. I will have to send it back. Tomorrow, my Lordship, is it humanly possible to update the CD
Who are the other 2 petitioners?
So far as submission of 143 is concerned, my lord, in 143, there has been trafficking. What my learned friend submits is it was supply. I'm not involved in any supply or trafficking. So 143 from the submissions also, it will not attract, will not be attracted to the petition.
No,
143 involves
suppose the girls were exploited by the guests.
my lord, my lord. My lord, then immoral traffic would come in, as was submitted yesterday. Immoral traffic act, there is no, my lord, this case is not under immoral trafficking. It is under human trafficking. For trafficking, there has to be recruitment and exploitation. Recruitment and exploitation both. So there is no recruitment. The submissions yesterday was the girls were called by the resort owner. So 143 is not a threat.
Okay.
And from my side, my lord, only 2 mobile phones and 1,750 words from my wallet was seized, my lord. Nothing else from me. Like I submitted yesterday, my lord.
But in your statement before police, you have indicated that you have some role in offense under 140 Lal Ring Geta, if I remember.
My lord, that instruction I didn't have. In fact, the specific instruction was.
No, that is 161
My-
statement.
My lord,
161.
once.
You can. We require up-to-date case diary.
Lordship.
Heard Mr. P.D. Nair, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This learned additional public prosecutor has submitted that the petitioner was apprehended in connection with Sonapur PS case number 113/2025 on which date?
16/7.
On 16/7/2025. And the case diary was produced before this court on May 23rd of July 2024. Stop. He further submits that though the case diary is lying before this court, in the meanwhile, investigation has been going on, and he. What is it?
We received the case diary on 22nd.
22nd.
22nd. And it was
He
placed before your lordship.
submits that considering the progress made in the investigation, an updated case diary may be called for so that the materials collected by the investigation in last 4 days, four or five, last 4 days, last 2 days, 2 days may be placed before this court. The prayer is allowed. When you can produce the case diary?
Only 2 days. 4th of August, madam, that's due date, madam. But only 2 days they have to produce. The rest, madam, in the forwarding report, it's already there for lordship. And last 2 days, and they are in judicial custody. They are not in police custody.
Yesterday, lordship.
From yesterday, they are in police custody, judicial custody, madam. So only 2 days, madam. On Tuesday, madam. Can be on Tuesday, only for 2 days.
Yes, Mr. Sharma.
It will be on 30, lordship.
29th, 1 day, madam.
Let it be on 29th.
They require to produce that part of the case diary or the statement with substance till tomorrow, till yesterday. That's it. What they will be finding in the
Not
next.
till yesterday. Till yesterday. Suppose.
Possibly this has happened like this, my lord. Definitely, my lord. First of all, my lord, certain persons were taken into police custody, my lord.
You're for?
That item, my lord, is all respect, my lord. Huh? One, my lord. Key one it is. Production list one. Oh, I'm sorry, my lord, production list one, my lord. Production list one, my lord. Silo.
No,
they were taken-
let me pass order in this case first.
I'm sorry, my lord.
You assume that your order will be same.
I have it, but only one. Can I place one line? Can I just place one line? What? Because up to date case diary is needed, my lord.
Yes.
Up to date case diary will be the forwarding report of yesterday, my lord. Because he said that certain persons were taken into police custody. Those things are not before your lordships, my lord.
Yes.
That whoever
Their
whosoever
statement.
the person is, my lord, who was taken into police custody or who were taken into police custody were produced yesterday. So everything is reflected there in the forwarding report.
No, apart from that,
Definitely, my lord, whatever interrogation was found out. So a diary till yesterday, my lord, that can be produced any day, my lord, with all respect, my lord. I'm not saying today, my lord. That has to be produced.
on
Up to date diary till yesterday, my lord.
not on yesterday, till the day before it is sent to the court. We are fixed. We are
Diary is before your lordship.
Yes, we are calling.
27. Thereafter, no interrogation in jail, my lord. Whosoever were taken into police
No,
custody.
there are some other vital witnesses. It is indicated that there are 5 victim girls
Yes.
whose statement are not there. If that comes,
Victim girl statements were there in the forwarding report. That is before your lordship, possibly, my lord.
no. If suppose one of the victim
Your
girls
lordship, please,
implicates you,
Yes, my lord. Then
then it will have
I have
impact.
understood, my lord. I have understood, my lord.
So whether you are implicated by any of the victim girl or not, that has to be
My
seen.
lord, victim girl implicating me would be an offence under the Immoral Traffic Act, my lord.
No,
That's a bailable offence.
whatever may be the offense,
My lord.
that we will
My
consider.
lord, then, my lord, can it be, my lord, any convenient because one a practicing lawyer, unfortunately, gaming
Who is
on
the,
any convenient date, my lord.
Well, some materials may be gathered till the end of investigation till 21st. Because some of the accused, at least I was produced before the court, and that day the bail application was filed, CD was produced, an elaborate order has also been given, and the reason for which the police remand was granted, that is also indicated, for which they want further investigation. Initially, they wanted to go for this immoral human trafficking. Then subsequently, they have shifted to the
Gaming part.
under the gaming part. These materials are there in my petition. Still 21st. Then yesterday they have been produced and they did not seek for any police custody. Rather, they have been given to the jail custody.
Even Apex Court has said, poker is not even a game. It doesn't fall within gaming also, my lord. That of course when up to date diary comes, my lord.
On merit, I am on a different petition. Because nothing was
no,
recovered from
let the updated case diary come.
So far as I am concerned, nothing is recovered. So therefore, I am in a different petition. I'll bring to your attention in my case.
What was the last line? When can you produce?
Actually, fixing it on 29.
29th. List this matter on 29th for updated case diary. Let the case diary be sent back to be called again after updation on 29th of.
Same order is on item number 1, my lord.
Item number production list.
I'm sorry, ma'am.
Production list. Same order. Council's name is B.K. Mahajan.
My lord.
Yes, Mr. Saikia.
My lord.
Why I say, I am in different thing, but your lordship will find the seizure list at page 44. This is the type copy. The original one is at page 47. Page 44.
Yes.
All these articles which are mentioned in the this FIR as well as the forwarding report, these are from the joint position of the
other persons. The first one is Silo, then second one is Realte, then third is Laringheta, and the fourth is Deepak Sekia. Not me.
Who are you?
I
Joseph.
ordered Joseph Lalparamuya. And in fact, from this particular list, which is also mentioned in the FIR at page 45,
Yes.
page 45, your lordship will find my lord, serial number 20, 21, 22, 23. These are from the possession of the other four parties, not from me. The materials of betting are from the joint position, and these are the individual position from which.
Now your role in 143 offense.
Yes, that also I'll come. It has not been in the FIR. They are trying to say that some kind of criminal conspiracy, etc. That might be. That's what their contention was. Now, so far as the forwarding report is there at page 45, page 25. Let's see, come to page 26.
Yes.
Well, ninth line above this ground of arrest, my lord. I just want to make it short, my lord. Ninth line above the ground of arrest starts with Nagaon. Line starts with Nagaon.
Yes.
Nagaon Assam was brought to the police station for interrogation, during which it was found that the 4 accused persons from the Mizoram were being provided shelter and other facilities by the resort authorities for conducting illegal gambling along with consumption of alcohol, tobacco, and were also suspected of involvement in human trafficking, with evidence suggesting that the club owner and the management were engaged in procuring and supplying when within the premises, thereby being part of an organized criminal network activities Assam, Mizoram, and other parts of Northeast. Is suspected. Now, my lord, on the first part, they were produced before the trial court on 16th. The lordship will find the page at 31. Page 31.
Yes.
Lordship may come directly to my lord, paragraph 36, page 36, paragraph 26. It's in finding of the trial court on the basis of the submission and the materials that has been submitted. In the instant case, the IO has seized the certain item which prima facie reveals that they might be used for gambling activities. And most importantly, the IO has produced certain pictures of women which are retrieved from the phone of accused Deepak Sekia, who is an employee in the club Navaran.
No, but now that is not the only material.
Yes.
There are statement of witnesses also.
Yes. Yes, this is the reason for which the police remand was granted, and thereafter they were produced on 21st July at page 62, that order. So that was for remand was police remand was for the unearthing any human trafficking was there. 62 is the order that has been passed. Well, in fact, I had filed in bail application before the trial court. And the page 64, relevant portion will actually come under. Page 64, paragraph 15. Par contra, the IO has prayed for police remand of 4 accused persons on the ground that seized mobile phones of the accused persons have revealed chats and other digital evidence which points to active involvement in international poker casino gaming network at that time might be wide network wherein the accused may be involved in dealing in huge amount of money illegally through gambling. So therefore police remand was given. But here point to be noted, you will see my mobile phone was not seized. It is only the 4 mobile phone of the other persons, not mine. So I was not at all required, my lord, for the purpose of investigation, even for this purpose, because my mobile phone was not seized by them. Yesterday they were produced and I was sent on, sent to the judicial custody. And Lordship will kindly come to page 13, my lord. But I am working as a secretary of a school, my lord.
You also booked a room there,
Yes, my lord, the school location was there, I had come, my lord. It is not that, my lord, they have booked,
But-
anyone had booked, my lord.
but
I
you-
was a guest. Not for betting.
you are
not for-
not staying in the room booked by Mr. Silo.
No, my lord. it was not that.
You booked on your own.
Now, your lordship will kindly come to page 55, my lord. Recently, my lord, a year back, my lord, 14/3/2000, he has gone another heart operation, my lord. At last, the medicines, my lord, he has to regularly take, my lord. And in fact, the order dated 21/7 also reflects, my lord, this position of the, my lord, accused persons, my lord. And then your lordship may come to, my lord, page 61. my lord.
What was the number of the room?
My lord.
In which room you have booked in the hotels, in the resort? The recovery was made from
Room number 8.
room number 8.
Room number 8.
And what are the 3 rooms from which?
138.
So from your room also some,
My lord will see the seizure list, my lord. It was joint possession of those other 4 persons, not me, my lord.
so it does not specify from whom.
It does not say that
That
I was also
Mr.
there, my
Nair has already said.
lord. And he's having also a minor daughter of my lord 1 year age, my lord, at page 61.
How he is involved?
But so the room number is there in the seizure list also, 8.
Yes.
Room number 8 is there, Lordship. Otherwise also, Lordship has gone to the statement of the 161 statement. He was fully involved, Lordship. At least investigation has to be done. He was there in the event. And it is not a fact that the room was booked on a single basis, Lordship. It was booked as a whole, Lordship. All the 32 rooms were booked. They were invited there, Lordship. They went there, Lordship. They took active part in the gambling operation, Lordship. So, and then, Lordship, the mobile phone details has been there, Lordship. All the chats are there. It has been looking.
It is not my mobile phone, not from me. My mobile phone. has not been
And
seized.
his role in 143 offense?
Lordship, on 29, I will test everything, Lordship. What is the progress, Lordship? What is there?
I pray in that case, my lord, interim, my lord, because he is a heart patient, my lord, suffering. Even if it is found from the, my lord, room number 8, my lord, the position, it has to be from the position, my lord, that is one of the.
No, there are two aspects in this case. One is games and betting,
Yes, that is not there admittedly, there's no betting.
and another is exploitation of girls. That is offense under section
Yeah,
143, which is more serious in nature.
More serious in nature. So therefore, my submission on the first date of remand, your lordship has seen, my lord, the remand was only for the purpose of unearthing, my lord, this human trafficking link with all the persons. Then on the next 21st, the allegations were against, my lord, those persons, owners and the employees regarding the human trafficking. They were not sought for, my lord, police custody. They were not sought for police custody. Only these 4 my lord, Mizo personnels were, my lord, sought for police custody.
Why your prayer was rejected by the,
My lord, yes, my lord, that order
where is the rejection order?
is 63.
64, para 15.
Page 64.
How you stand on a different footing from that of Lal Rem Gheta or Mr. Nair's claim?
Because, my lord, Nothing was recovered from my possession, my lord. Though FIR they have tried to implement, but this FIR has been lost after the seizure. And seizure has specifically said from the joint possession of the other 4 person, not me.
Where is the rejection order?
My lord, it starts at page 62. The rejection given only, my lord, paragraph 20 onwards, page 64. Because of the stage of the investigation.
No, up-to-date case diary would be necessary.
Pay for, my lord, interim, my lord, release, my lord, on any condition because of the health condition.
What is your health? Where is the document?
My lord, at page 55, my lord. Five days, my lord, inpatient, my lord, heart operation was done, my lord, and after this series of, my lord, these medicines has to, my lord, taken by him.
How are you different between this man?
Second time remand was sought only for, my lord, this chats, etc., which were found in the mobile phone, which were seized. My mobile phone was not seized. The trial court, considering the stage of the, my lord, investigation, given 2 days custody.
No,
And thereafter, yesterday,
what ailment you are suffering?
my lord, this is basically what is, my lord, the artery blockade, my lord. Myocardial infection.
Myocardial infection. You can wait till 3-4 days. We'll direct the jail authority to provide you. Heard Mr. P.J. Sarkar, London. Senior Counsel assisted by Miss M. Kechi, Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor, who submits that though the case diary is available before this court, however, in the meanwhile, investigation has progressed, and he prays for allowing to produce an updated case diary before the court. Stop. Considering the fact that apart from acquisition under Assam Games and Betting Act 1970, there is an allegation of involvement of all the accused persons named in the FIR in the offence under section 143 of BNS, and considering the nature of accusation, this court deems it proper to peruse the updated case diary for consideration of the instant bail application. Hence, call for the case diary. Release this matter again on 29/7/2025. Learned Senior Counsel for the petitioner has submitted that the petitioner is a patient of heart ailment and has been discharged from hospital on 9/3/2024. After 24, this is the latest. Okay. Has stop. Considering the submissions made by Learned Senior Counsel, the Superintendent of Central Jail, Guwahati, is directed to provide all necessary treatment to the petitioner after conducting a general health checkup of him during the period of detention in the Central Jail, Guwahati, list this matter again on 29th July.
Further adding, including food, food is also materials for the family members, restricted foods, that also if superintendent takes care of it.
What was the line? All necessary treatment / measures. I'm not specifically mentioning if doctor thinks it necessary. He will take all
They were asking me to send him to police custody, at least they can, supply some food, item, but now he is in jail custody.
wait for a few days.
Always.
Yesterday's matter is fine.
You have to wait for little time.
Matter was passed over because the case was not there at the time. Suppose the data was stopped.
ভিতর দিব।
It's the anticipatory bail application. Worship will kindly come to page 14, which is the FIR.
What is the offense?
Offences are under my lord substance 303, this is theft, my lord, 317, receiving stolen property, 3175, which is assisting in the concealment or disposal of stolen property. Then say 24, 25, 40 and 49 of the forest regulation, and 17C, 17B and 51 of the wildlife act. Primarily pertains to recovery of 28 pieces of red sandalwood in the house of one Matla Murmu. Now, Matla Murmu says that these red sandalwood was kept in his house by me.
Who are you?
I am, my lord, Binay Bhagat, my lord, page 14, my lord. So I may take your lordship.
Okay. Yes.
The facts of the case are as follows. On 14/6/2024, at around 8:10 p.m., information was received by the SDPO Gosaigao from a reliable source that suspected red sandalwood was being stored in the house of Matla Murmu at village so-and-so. Accordingly, I was enrolled by the OC Gosaigao PS, and on the same day, I proceeded to the location along with the OC and available police staff under the leadership of SDPO Gosaigao. Upon conducting a search of Matla Murmu's house, 28 pieces of red sandalwood were recovered. During preliminary inquiry, it came to light that the red sandalwood had been kept there by one Sri Vinay Bhagat, son of so-and-so, so-and-so, for the purpose of illegal smuggling. It is also suspected that other individuals may be involved in this crime. Accordingly, the 28 pieces of red sandalwood were seized by me in the presence of witnesses, and the seizure was duly recorded through the e-saksha. No matter my apprehension is because I'm named in the FIR. No matter whether my detention is required or not, the foundational, the edifice of it is whether the sections under which I have been booked or the case has been registered are actually attracted in the case or not, as they stand today, not on some future contingent date. So your lordship will kindly see the sections, madam. First is 303 subsection 2, which is theft. Theft requires that I have to dishonestly move somebody else's property without the consent of that person. So the first requirement is that it has to belong to somebody, and without the consent of that person, I have to take that property. Likewise, in the case of receipt of stolen property or assisting in the concealment of stolen property, the primary consideration remains the same. Somebody else's property was taken without his consent. Now, my learned friend will enlighten this honorable court as to whom these alleged red sandalwood belong, from whom these were taken without the consent of that person.
Suppose you remove it from some reserve forest.
In that case also, materials will have to be there to
That
show that these were there, because somebody has to come forward and say that this belonged to this particular reserve forest and this was taken from there. Those materials will have to come in the case. If it is there, then offences will definitely be attracted against me.
That is my first submission, my lord. Now, second point is, my lord, the other offences are 24, 25, 40, and 49 of the Assam Forest Regulation. The section 24, if your lordship, has the Assam Forest Regulation.
Assam Forest Regulation.
Right. I can just give the gist of the provisions, my lord.
Yes.
24 Assam Forest Regulation deals with trespass or damage to reserve forest, my lord. So I have to trespass or cause damage to a reserve forest, then it is punishable with 3 years imprisonment. So again, if the case there supports that allegation. 25, my lord, comprises a multiple number of acts, my lord, which are punishable. One is clearing a reserve forest. Another is setting fire to reserve forest. Another is carrying fire into reserve forest. Another is felling or cutting, etc., of trees. Then quarrying stone or lime, etc., in a reserve forest. Then, my lord,
Mainly the accusation is you fell sandalwood trees from some reserve.
my lord, that is what they are in the, because what has been alleged in the FIR is that 28 pieces of red sandalwood has been found. It has not been alleged in the FIR, subject to what is there in the case diary, that red sandalwood trees have been felled. And I am, perhaps, my lord, red sandalwood is also not indigenous to the reserve forest in Assam, my lord. We will be able to enlighten on that as well. So these, and then, my lord, the other offences are section 40 and 49. These are not penal offences, my lord. 40 is power to make rules for regulating the transit of forest produce. 49 is seizure of property, which is liable for confiscation. So these two are not penal provisions. Now, the most important provisions, which would be, my lord, under the Wildlife Act. 17C, Wildlife Act.
Wildlife. Yes.
17C is, my lord, cultivation of specified plants without license prohibited. The prohibition of cultivation of specified plants. So we'll have to go to the schedule to see which are these specified plants. 17D is dealing in specified plants, the prohibition of dealing in specified plants without license. Now 17C and 17D, my lord, D is come under schedule 3. Now, schedule 3, my lord, because these are chapter 3A offences. So the those items which are there in schedule 3, in case of those articles, my lord, their cultivation as well as their dealing is prohibited without a license. Now, schedule 3 does not contain, my lord, red sandalwood or its scientific name. Red sandalwood only comes in schedule 4, my lord. And schedule 4, in, against entry number 444, that is Pterocarpus santalinus. That is the scientific name of red sandalwood. Schedule 4, my lord. So, lordship will find it at page 205 of the Act, my lord. That's the same. It's not the same. For 444 entry, that is Pterocarpus santalinus, that is the scientific name of red sandalwood. This was incorporated, my lord, by the 2022 amendment into the fourth.
What schedule 4 deals
Schedule
with?
4, well, Schedule 4 is primarily concerned with the infraction of chapter 5B, my lord. 5B of the Wildlife Protection Act.
What is 5D?
Chapter 5B, my lord. I'll just come to chapter 5B. 5B is, my lord, regulation of international trade in endangered species of wild fauna and flora as per Convention on International Trade in Endangered Species of Wild Fauna and Flora. So 5B basically prohibits, my lord, international trade or basically, my lord, smuggling across international borders. So that has been brought in by way of the 2022 amendment, my lord, into the Wildlife Act. So, my lord,
Which provision section?
My lord, it starts from section 49D, my lord. It's 49D my lord, gives the definition 49H starts, my lord. 49H, my lord, international trade in scheduled specimen and restrictions in respect thereof, my lord. And 49I is conditions for export of scheduled specimens. 49J is conditions for import of scheduled specimens. K is for re-export of scheduled specimens. Others may not follow. So primarily dealing with international trade of these scheduled, whether it is species of animals or flora and fauna. So that has been brought in by the 2022 amendment into Schedule 4. 17C and 17D deal with Schedule 3, where this red sandalwood does not come from. So the offences, my lord, which have been included in this FIR, my lord, these are not attracted, at least when my friend may enlighten this court, what is there in the case diary. So mere possession by one person who says that I had given.
No, whether possession of an.
It's not punishable under this act, my lord.
Land.
Is not punishable under the Wildlife Code. They would have to find some other provision to register the case under. As the offences which stand as on today, my lord, none of these offences is attracted against in this case, let alone against me, my lord.
Yes. This has to be gone into.
My lord.
Now. What schedule? This 444 falls within which schedule?
Schedule 4, my lord.
Schedule 4 deals with?
Schedule 4, my lord, deals with.
Where it starts?
Start at page 145. Chapter 5B, my lord. It also mentions other sections, but those are relating to wild animals. All the offences, my lord, they carry a maximum punishment of 3 years. My lord.
So your basic submission is that possessing sandalwood
is not covered by any of these provisions.
Is not an offence.
Based on the offences which have been under which the FIR has been registered, my lord, those offences are not attracted on mere possession of sandalwood. And here, my lord, I am not even in possession. One Mahatma Murmu was in possession. He says that I have given it to him. Assuming that to be correct, my lord, even then these sections are not attracted against me. If there is any other section that is for the, I am not going to help the prosecution. They can go ahead and find if there is any other provision which is attracted. But that will be a future event, my lord. As on today, my detention is going to be decided on the offences which are attributed to me as on today.
Suppose the facts constitute an offence, which reveals from the narration of the fact in the FIR. But the police or the registering authority quotes a wrong provision. That may not help you.
But in my respect for submission, it is for the state is looking to arrest me or state has already arrested a person based on certain offences. The accusation is in respect of the offences which are there in the FIR. If suppose, my lord, and giving a different analogy, my lord, an FIR is registered under a bailable offence, my lord. Even if a non-bailable offence is committed, if the FIR is registered under a bailable offences and I'm arrested, I'll still be entitled to bail unless and until they add the non-bailable offence.
That addition
has to be done from their side.
You find out what is your submission.
First, as my friend has already stated that, okay, one, it is in the possession of.
No, or I'm giving you two options. His basic submission is that the penal provision, the provision quoted in the FIR under which the case has been registered is not attracted under the facts and circumstances of the case. His core of his submission is that you have failed to show that possessing sandalwood without any documents or is not an offense. He's not saying that it is not an offense. You have not stated in the FIR under what provision it is an offense. So you may reply to his submission now itself, or you may.
But one thing he has stated that one for purpose of illegal smuggling. He has stated. And in that count, Lordship, I want to state here that one letter has been sent to the principal chief.
No, why
conductor of forest.
this matter is not dealt with by special public prosecutor for
Lordship.
wildlife?
Because wildlife is not investigating the case, Assam police is.
Okay.
We have still made them a party in the case, but since it is the case being investigated by Assam police. So they may obtain instructions or they may go, and in that case, will protect him.
A report is called
They
for.
obtain the necessary.
A report is called for regarding this detailed report from the forest department, Lordship. It has not come yet.
Let the report come, till then I may be protected.
And moreover, it is here, Lordship, if I look into the CD, that one witness is also there, Lordship, who has stated that he has kept it in the house of.
No, that is what he is submitting.
That's it.
Keeping sandalwood in itself, whether it is an offense or not. You have to pinpoint that.
But for illegal,
Unless they can show I have stolen it, I have either fell the red sandalwood tree, or I am smuggling it across the state country's border. If those three elements are not there, then
it is on that line also, Lordship. It has encouraged organized smuggling network, Lordship. It is going on that direction only, Lordship. Investigation is going on that direction, Lordship.
Under what provision? What is the offense? Mr. S. Nawaz, learned counsel for the. Yes, Mr. Das, what is your?
I will call for the report, Lordship. At least, Lordship.
What report?
From the forest department, Lordship. It is called for. A letter is there. A detailed report, Lordship. Request for deputation of expert team for identification and other authentication and for the purpose of illegal smuggling.
Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Binay Kumar Bhagat, alias Binay Bhagat, who is apprehending his arrest in connection with Gosaigaon PS case number 79/2025 under section 303 within bracket 2/317 within bracket 2/317 within bracket 5/3 within bracket 5 of BNS 2023, read with section 24, 25, 40, 49 of the Assam Forest Regulation 1891, read with section 17C, 17D, and 51 of the Wildlife Protection Act 1972. The gist of accusation in this case is that on 14/6/2025, Rashmita Saikia, SI of police, had lodged an FIR before the officer in charge of Gosaigaon Police Station, inter alia, alleging that on receipt of an information through reliable sources that suspected red sandalwood has been stored in the house of one Malta Murmu at Haraputta village, a search team was constituted and the house of the said Malta Murmu was searched. Stop. During search operation, 28 pieces of red sandalwood were recovered from the said house. During investigation, during preliminary inquiry, it came to the light that the said red sandalwood had been kept there by the present petitioner for the purpose of illegal smuggling. No provision for illegal smuggling has been incorporated.
It's there, madam. Chapter 5A is there, madam. But that is only in case of international smuggling, madam. That's what I was trying to submit, madam. If there's anything to show that I was engaged in illegally smuggling this red sandalwood across the nation border.
Chapter 5A relates to Schedule 3.
No, sir. Chapter 5A deals with Schedule 4.
Schedule 4.
Where, my lord, red sandalwood is there.
Okay.
That was brought in 2022.
And what is the
17C and 17D, which have been invoked here specifically, my lord, those pertain to Chapter 3, my lord. Schedule 3, my lord. Where red
So
sandalwood
there must be some penal provision
for, my
corresponding to Schedule 4.
lord, Schedule 4 is there. Section 51 is the penal provision.
Yes.
Section 51 penalizes across, my lord, for all offences. Section 51 is the penal provision. Now, what they have invoked is 17C and 17D. 51 is
51 has
the
all.
penal provision. Is the penal provision. But for infraction of which provision I am going to be penalized by. Those substantial provisions are what they have invoked as 17C and 17D, which are attributable to the list in Schedule 3, where red sandalwood is not there.
And there must be some penal provision corresponding to the Schedule 5 also.
Schedule 4 is there, my lord.
Schedule 4.
Schedule 4 is also if in case of any infraction of the substantial provision vis-a-vis Schedule 4 list, it is still punishable under Section 51. My respectful submission was that, my lord, since red sandalwood comes under Schedule 4 deals with the offences which are there in Chapter 5A. Chapter 5A offences have not been invoked in this case.
Okay. For that, you may not get interim bail.
For them, on that dimension,
Let
the
him-
SIR is there, my lord. If they can show that there is any infraction of the Chapter 5A offences, my lord, I am not entitled to bail per se, my lord. Not even interim, my lord, I am not even entitled to bail.
Yes.
For that, I'm saying that, Lordship, a report is there, calling for a specific report.
No, that has to be in the case there.
It
You
is-
may
it is-
take instructions.
Lordship,
I'm
I
giving you.
take instruction regarding this report, Lordship.
क्या लिखा है अभिषेक? Be louder. Smuggling. Learned counsel for the petitioner has some regarding your accusation that you have kept it there.
No, that part is denying.
Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offence alleged in the FIR. Nothing was recovered from the possession of the present petitioner, and the accusation made against him that it is on his behest that the seized sandalwood were kept there is denied by the petitioner. Learned counsel for the petitioner has also submitted that the penal provision, the penal provision under which this case has been registered is not, none of the penal provision under which the case has been registered is attracted under the facts of this case. He submits that though the acquisition has been made under section 303 within bracket 2 of BNS, as well as 3117 is
3117, 2 is my lord, receiving, dishonestly receiving or
stolen.
property. And 5 is my lord, dishonestly assisting in concealment or disposal of stolen property.
And 3175 is are incorporated. However, he submits that there is no acquisition in the FIR that the sandalwood recovered from the house of Malta Murmu were stolen property or were the subject matter of any theft. He further submits that the provisions of Assam Forest Regulation 1891, which are added in this case, are also not applicable in as much as Regulation 24 deals with
Trespass or damage to reserve forest.
but there is no acquisition to that effect in the FIR against the present petitioner. Similarly, he submits that Regulation 25 deals with
It's a long list, my lord, including, my lord, clearing forest, setting fire to reserve forest, felling or cutting trees, and clearing stones, etc.
deals with offences inter alia, felling and cutting of trees, etc. However, to that effect also, no accusation has been made by the informant in the FIR. He further submits that Section 17C and Section 17D of the Wildlife Protection Act relates to
Prohibition of cultivation of specified plants and prohibition of dealing in specified plants without license.
Repeat again.
Prohibition of cultivation of specified plants and prohibition of dealing in specified plants without license.
He also submits that those specified plants are mentioned in Schedule 3, which does not include red sandalwood stuff. He submits that the red sandalwood is included is there in Schedule 4, and no penal provision apart from
Substantial provision.
no substantial provision of
Chapter 5A minus.
Chapter 5A has been included in this case, for contravention of which
He may be punished under Section 51.
yes, he may be punished under Section 51 of the Wildlife Protection Act. He therefore submits that the facts in this case suggest that none of the penal provisions under which the aforesaid case has been registered are attracted. Hence, he prays for allowing the petitioner to go on anticipatory bail. He further submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned
Lordship, I
Eddie.
also want to focus on the point that as he has stated that he denied that he has kept
No,
it in
no,
the
I am not giving interim bail now.
Lordship.
You take instructions and in
Lord.
light of what he has submitted
Lord.
and reply, then we will
Lord.
consider. On the other hand, though learned additional public prosecutor has produced the case diary, he submits that in view of the submissions made by learned counsel for the petitioner, he needs to take appropriate instructions from the investigating officer before replying to the said submissions and prays for some more time for the same. How much time?
Lordship, on your code.
Eight.
Eight.
The prayer is allowed. Let this case be listed again on 8th of August. The case diary, which is before this court, may be retained,
No, we have to.
may be returned back
Some-
to be called back after updation on the next date fix.
On the report, sir, they've already called for the report. So perhaps the problem here is, my lord, now we have,
It will not come.
As
that may not come in also, my lord, because we have specifically said that these offences are not, it has not been. I have the option now of adding other offences and then.
They can add.
Lordship, they can add it.
So,
During the
shorter
investigation.
date perhaps.
Moreover, Lordship, the wildlife department is also there as a party. I will talk to them also, Lordship.
Shorter deal, my lord. So only report is required, but let it come on my first possible.
I insist on 8th, Lordship.
Let it be on 8th.
Lordship.
Eighth.
Much obliged.
Come deeply obliged, my lord.
This is an application under 483 BNSS. Here your lordship petitioner has been arrested on 29.
Item number 7. Yes.
It's an application under 483 BNSS. your lord. Here the petitioner was arrested.
You are ready, NCB?
Sure.
Okay.
Petitioner was arrested on 29/11/2022. Now already nearly 2 years, 8 months in custody. There were under section 20 B2C. The recovery was 195.7 kgs of ganja from a truck, your lordship. This is intercepted and
How much? How much? What truck?
195.7 kg of ganja was intercepted from a truck from which one person was arrested. From the truck, Ganesh Kumar, and subsequently, your lordship, under section 67, on the statement of the co-accused, Mr. Ganesh Kumar, this person was arrested. The present petitioner was Rajiv Roy, who was arrested, your lordship. And in that case, your lordship, charge sheet was submitted on 25/5/23, and charges were framed on 22/9/23 itself. There were 16 listed witnesses, of which only 8 has been examined. Now, my case will be basically on 2 grounds. One is, your lordship, long incarceration. Because, your lordship, in this case, more than 2 years, 8 months already in custody, and out of 16 listed witnesses, only 8 witnesses have been examined. Now, your lordship, with regard to the other 2 persons who were arrested, Ganesh Kumar, who was the person who was caught from the truck, and another 1 person, your lordship, they have already been granted bail by this honorable court. I have annexed both the bail orders, your lordship. In those 2 cases also, your lordship, apart from the long incarceration, the grounds of arrest, not providing ground of
No.
arrest, were also there. And
They were co-accused.
lordship,
Co-accused in this
yes,
case.
2 co-accused have already been granted bail. I have annexed the orders of the
Where? At
of this honorable court.
which page?
That your lordship will find at page 83 is the
that Ganesh Kumar, the main accused person again, from the truck where the ganja was recovered, this person Ganesh Kumar was arrested, and on his, your lordship, statement on the 67, the present petitioner Rajiv Roy was arrested. So this was page 83 is a very long judgment, your lordship. It pays ultimately the court has granted bail, which is at page 102. So it's a very long judgment, more than about 21 pages judgment. All these issues which I have raised with regard to long incarceration, and in that case, your lordship, the grounds of arrest were not provided, and that was also argued, and that's why it's a very long judgment. And here also, your lordship, now that was long back, that was on 5/5/2025. Now, your lordship, the period of incarceration has come up to 2 years, 8 months. So therefore, your lordship, my first ground is with regard to long incarceration. Second ground is, your lordship, with regard to the bail granted to the co-accused. And thirdly, your lordship, with regard to the, I've been arrested only on the statement of the co-accused under section 67. So I'll also bring in Tufan Singh. So these are basically my grounds.
Yes. What is your submission?
I plead your lordship. Your lordship, out of 16 total witnesses, 10 have already been examined, your lordship, as per our instructions received from the department, your lordship. Also, your lordship, there is sufficient evidence that they are involved in an organized crime, your lordship. Sufficient monetary transactions between the co-accused to establish the involvement of the crime, your lordship. 195.7 kg of ganja was recovered, your lordship, which is also a commercial quantity, your lordship.
And in fact, your lordship, the other judgment, the second order of bail, that is with regard to the other co-accused, that is at page 104. One is at 83, another is 104. In both cases, your lordship, they were granted.
Heard Mr. Y.S. Mannan. Anything else?
Your lordship, the trial is proceeding in a fairly... Next date of evidence has also been fixed, your lordship, 13th of August 2025. So, your lordship, there is no delay in trial also.
What is your response to the submission that one of the co-accused has been granted bail?
Not one,
two of the co-accused, amongst other, on the ground of prolonged incarceration. When other two have been granted bail on that ground, why should this petitioner be deprived of? How his case is different? Heard Mr. Y.S. Mannan. You have to make some submission. Heard this Y.S. Mannan, learned counsel for the petitioner. Also heard Miss, what is your name?
P. Upadhyay, your lordship.
P. Upadhyay, learned counsel appearing for NCB. This application under section 483 of BNSS has been filed by the petitioner, namely Rajiv Roy, who has been detained behind the bars since 29/11/2022, for last more than 2 years, 8 months, in connection with
NDPS case number 20.
NDPS case number 20/2023, arising out of NCB crime number 23/2022 under sections 20B2C/29/35/54 of the NDPS Act, pending before the Court of London, Special Judge Kamrup Amingao. The gist of accusation in this case is that the NCB on receipt of an information through reliable sources. Where is the
Lordship will find that at page, 18.
tell
18, your lordship. And
on 28/11/2022 that one person would be carrying huge quantity of ganja in a truck bearing registration number NL01AB4248, a search operation was conducted and the above mentioned truck was intercepted. And who was arrested from
Yeah.
the
page 20, Ganesh Kumar, page 20, the second paragraph stated.
The driver of the said truck, namely Ganesh Kumar, was apprehended, and during search 190, how much?
195.710.
195.710 kg of suspected ganja was recovered from the state truck. Learned counsel for the petitioner has submitted that the petitioner is seeking bail in this case mainly on 3 counts. Firstly, he has that he has been detained behind the bars for more than 2 years, 8 months. However, the trial has not progressed much, as out of 16 listed prosecution witnesses, 10 or 8.
10, you know.
At that point of time, but since it is an updated,
10,
it may be 10.
only 10 prosecution witnesses have been examined, and there is no hope of early culmination of the trial. He further submits that long incarceration of the petitioner has infringed the fundamental rights of the petitioner guaranteed under Article 21 of the Constitution of India. And under such circumstances, the embargo of Section 37 of the NDPS Act gives way to the fundamental rights guaranteed under 21 of the Constitution of India. He further submits that in the meanwhile, two co-accused persons have already been granted bail, namely Shri Lakshman Roy, Shri Ganesh Kumar,
and Lakshman.
And Ganesh Kumar, within brackets, on 5/5/2025 in bail application number 170/2025, and Shri Lakshman Roy on, within bracket, on 9/5/2025 in bail application number 1286/2025, bracket close, by a coordinate bench of this court. Learned counsel for the petitioner has also submitted. Thirdly, learned counsel for the petitioner has submitted that the petitioner has been implicated in this case merely on the basis of the statement of the co-accused recorded under Section 67 of the NDPS Act. Apart from the said statement, there is no other material to implicate him in this case. He submits that the apex court in the case of Tufan Singh versus State of Tamil Nadu reported in citation
2021 4 SCC 1.
has observed that the statement of co-accused is not admissible as evidence in a case involving offence under NDPS Act. Under such circumstances, he submits that the petitioner is entitled to get bail in this case. On the other hand, Ms. P. Upadhyay, learned counsel for NCB, has vehemently opposed the grant of bail to the present petitioner on the ground that the quantity of contraband seized in this case is of commercial quantity, and therefore embargo of Section 37 of the NDPS Act is applicable to this case. She submits that the trial has fairly progressed and already 10 witnesses have been examined by the trial court, and only 6 of the prosecution witnesses remains to be examined. And it is likelihood, and there is a likelihood that same would be expeditiously done. Any other thing? Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Apparently, it appears that 2 of the co-accused persons have already been granted bail by a coordinate bench of this court, inter alia on the grounds of prolonged incarceration.
In fact, in those cases, non-submission of the grounds of arrest were also taken. I'm not taking it.
Inter alia amongst other. Stop. The apex court has from bail application number 329/2025 dated 6/3/2025, Port Para 10, 11, 12, 13. In the instant case also, this court is of considered opinion that the incarceration of the petitioner for more than 2 years, 8 months, in this case, may be considered as long enough to infringe the fundamental rights guaranteed to him under Article 21 of the Constitution of India. And under such circumstances, the fundamental right guaranteed to the petitioner under Article 21 would override the embargo of Section 37 of the NDPS Act, 1985. There is nothing on record to indicate that the petitioner has been at fault for the long delay in culmination of the trial. And when no delay, no fault may be attributed to him for such a long incarceration, he is entitled to get bail on the ground of prolonged incarceration due to infringement of his fundamental rights guaranteed under Article 21 of the Constitution of India. In view of above, the petitioner named, the above named petitioner is what was the contraband? Above named petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount, subject to the satisfaction of learned special judge Kamrup Amingao, with following conditions, bail conditions of NDPS. This bail application is accordingly disposed of. What is the next item?
Yes, so I have the next 67 lordship. I am on behalf of the Ranjan Kumar lordship.
What is-
Similar submission.
What is the date of your application?
Date of appearance is 30/11/22 lordship. And in this case also, I have been arrested on the basis of the statement of the court.
30/11/22. Wow. How long you are behind the bars?
Behind the bar lordship, 2 years, 7 months, 23 days lordship.
Abhishek, same order. We are granting bail to him also. Same order. Council's name is heard Mr. R. Borwa. Remains same. 1 lakh with 2 sureties of like.
Deep. Deep.
Here, this matter first came up before lordship on the 18th lordship, on that day my learned friend says lordship that the case diary is here. So accordingly, your lordship picks along with the case diary lordship. And FIR your lordship will find page 30.
It is motion item.
Actually, on first date, it has come for motion, now it has come for hearing lordship along with the case diary. Because case diary was present on the first day itself for in connection with another case lordship.
Yes.
Page 13 is the FIR lordship. Your main allegation is that lordship, some persons obtain loan lordship from bank by showing false documents, and accordingly this FIR was lodged. And the lordship will find that my name appears in page 17, serial number 31. Page 17, serial number 31. I took
Nobin
loan of,
Das.
yes, I took loan of rupees 7 lakh as personal loan, and thereafter 10 lakhs for my store lordship. And I was paying my EMIs duly lordship, but in the month of April, May lordship I could not pay. April lordship I could not pay my EMI. And thereafter the present FIR was lost, and because of this FIR my account was declared to be NPA lordship, and now they are not accepting that EMI, but I am trying to settle the issue with the bank. I am ready and willing to repay my loan. It is not a case that I will not repay my loan amount. In fact, if your lordship perusses paragraph 4 of my petition, specific averment is there that he is ready and willing to repay, but because of loss in business, he could not pay for the month of April 2025. That is my case.
Where is the indication that you were paying loan?
Paragraph 4, lordship, page 4.
No,
And
apart from statement,
lordship.
apart from your statement, is there anything to show?
Documents are there, lordship. I will produce before the investigating officer, lordship, because it is the bank statements will be there, lordship. And he could not, because he is outside, lordship, he could not collect those documents, lordship.
No, before that you have to satisfy this court.
That my learned friend can say, lordship, because I have made my specific averments here, and if you can say that these are not correct, then
Yes.
things will be different, lordship.
Fact is, 53 numbers of loan account were allowed, not approved, and subsequently found that some documents are fake. Some accounts were become NPA, but some documents found fake, the taking the GST and number, and particularly now, regarding this petition, the bank manager, one earlier bank manager was arrested, but there are 7, 8 agent and staff, they are also involved. Now regarding this petition, Nobin Das. His, this, shop was name is Dastor. And 3,55,000 lakhs, 3,55,000 was the loan amount. The quotation is fake as the GSTN belonged to a T company and the account number belongs to Navin Das. He's showing the name, name of Dastor, but it's a T company and GSTN is fake. Malad may kindly go through the CD. I'll hand over the CD, Malad. Though investigation is the initial stage, Malad, very initial stage, but this 53 account, Malad, loan account was found either fake document or some are Malad NPA. Now, particular to this Malad, Nobinda Sahib flag mark Malad, GSTN is fake. So,
What is the offense here?
Malad,
Offense.
taking loan, Malad, giving Malad false fake document, Malad.
What provision is there? 316.
316, 25 and 318, Malad.
316, 2, 3165, 3184.
What is this?
Idea for two.
What is 316? Criminal breach of trust.
Malad.
316,
362 is, who is whoever commits criminal breach of trust shall be punishment. And 5 is whoever being in any manner entrusted with the property or with any other revenue of the property in his capacity of a public servant or in the way of his business as a banker, merchant, factor, broker.
Whether
attorney,
it
or
is
agent.
attracted against the present petitioner, any of the provision.
because the banker manager is granted anticipatory bail that I have.
No, you are neither manager nor banker.
Banker is granted bail, that is page 21.
318 shipping, Malad, his document is fake.
That page starts from page 21, paragraph 5. Your lordship will find that he was the bank manager.
During the preliminary investigation, Malad,
Initially granted
bank documents, details of bank documents is here.
Baro karne ki mana se.
Because main thing is that he is not, he is willing and ready to pay, and he was paying lordship, right?
Tomorrow I will take pass orders.
I am doing the schedule.
Case diary would be nice.
So item number.
No.
Item number lordship.
Let me
Item
let me dictate the order of the heard. Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor. Will it be
At 10:30 or 2, the time may be fixed. Otherwise, again, may not reach.
no, tomorrow I will deliver
Lots.
or should it be on Monday?
I leave it up to you, Lord.
It should be on Monday. I have lot of work. List this matter for delivery orders on Mondays, 28th.
Oblige.
Yes.
But I think. Several times it was. Should be available, Malad.
Next week we Next week again, it would be difficult. Putul suggested it. 1st of August.
My lord, item 22, my lord.
Due to paucity of time, this matter could not be taken up. Is this matter on 1st of August? Any matter where statutory period is over.
Item number.
Item number 31, my lord, 51 days interim, my lord. As on today, 51 days, next week, any date, my lord. 60 days mandatory.
Not available from earlier, my lord.
When can you produce?
28, my lord. 28 million. 29 then.
No, he has to produce case.
Wow.
37.
Item number 29, lordship, as on today, 55 days. 60 days is mandatory.
When it will be 60 days?
It will be, lordship, on by 28, it will be over. lordship.
28.
On 28, it will be over. lordship. Can it be, lordship, tomorrow?
Tomorrow again, it may be
Because lordship, already 55 days as of today, lordship. So he will complete 55 days today.
CD is there.
Item number 50?
55, item number 29.
29 CD not available. man. Oh, I already got my lord.
But
On Monday.
Monday.
My lord, I have a similar thing with regard to item 68. Can it be taken up on Tuesday, my lord? PCR is already there, my lord. 68 months supplementary. item.
What is the period of detention?
My lord, he is in custody for last 3 years, 5 months almost. my lord.
NDPS matter?
Yes, my lord. TCR is, that is why I am paying, my lord.
No, TCR will remain.
Yes. Kindly, my lord, on Tuesday, my lord.
Your lordship.
Supplementary item 68.
Okay, Tuesday.
Item
Friday or
22, my lord. Charge sheet has already been submitted and case has been already committed, my lord. So liberty may be granted to approach the trial court.
Which item?
Item 22.
22. Heard Mr. R. Ali, learned counsel for the petitioner. You are withdrawing.
Liberty may be granted with liberty to approach the.
Liberty is always there in
Lordship.
criminal case. Just a minute.
Lordship.
Learned counsel, also Mr. K.K. Parashar, learned additional public prosecutor, who submits that charge sheet has been.
I don't have information. I have obtained the order also.
Learned
Case has
counsel,
already been committed.
learned counsel for the petitioner submits that he may be allowed to withdraw this case as he intend to approach the trial court for seeking bail. The prayer is allowed. This case is dismissed on withdrawal.
If you're not. So matter may be taken up tomorrow at 2 p.m. Kindly.
Tomorrow at 2 p.m. you are giving date and time, everything. Case diary is there.
There is there, but it need to be updated.
What is the offense?
Commercial quantity, but your lots of grounds of arrest does not.
CD is, we have received on 4/6. And since then it is not updated, it need to be updated. FSL is not there.
In the brother is the cancer patient and they have a.
First, retain it for till on first of August.
Yeah, please, lordship. My lord, item number 30, my lord. LCR is available, my lord. So it may be listed on Monday, my lord.
What is the offense?
This is section 6 of POCSO, my lord, and he is behind the bar for 10 months, 10 days, my lord.
What is the status of the trial?
My lord, already victim and the informant has been examined.
First of the February. 4th of August.
Item
4th of August.
Obligation.
Item number 38 was listed on 24 and today it's proceeding. Facebook comment portion.
Case diary is there.
No, actually not with me. 69 days in public.
The communication
What is your prayer?
Taking by the IO. That one.
It will be reposted. Before that. 5th of August.
69 days was in custody. Too late was in. 69 days in custody. Can it be on 28 or so? 28. Already 69 days in custody.
28, you will be able to produce the case diary.
One was CD to the lotion. Delay first demanded lotion. On 301.
30 July.
Please, Your Lordship. Lordship, item number 52 and 53. There is an interim protection that may kindly be.
It will continue.
And next date will be.
Next date registry will give.
Yeah, please, Your Lordship. Lordship, item number 27 was fixed for today. Can it be, can it be taken for tomorrow in the first 10 matters?
Not tomorrow. What is the
It's commercial quantity, Lordship.
commercial quantity 8th?
Can copy perhaps not received, official is there, it's not is there.
You should,
Kindly keep the matter for tomorrow.
scan copy is not there. Heard, Mr. What is your name?
Jayamalya Bhattacharya.
J. Bhattacharya. It appears that the scan copy of the case record trial court record has not yet been received. Issue reminder for the same. List this matter on 8th of August.
Item number
27.
Yes,
Item number 54, my lord. Can it come up on 7th? Case there is going.
case diary is there. Okay, 7th.
And there is an interim order that may be coming.
Interim order. Interim order, then it will, case diary is there. The interim will continue. Date dio. 13th of August. Item number 13. 39, interim shall continue. List this matter on 19th of August.
May please, Your Lordship. Item number 43 and 44. These two items, interim protection is there. Lordship may be continue the interim protection.
43, 43, 44. Interim shall continue. List it on 19th of August. It is updated. The case diary which is available may be sent back to be recalled again on the next date.
Item number 28. This year is a citrus. On 28 it possible.
28, it is not possible. Item number?
28.
What is the offence?
This 142, 3, or we did make it 5 and 6 box of.
6 books.
197 days is behind the work.
11th of August. 11th August.
Maybe this lordship, I will mention item number 45, interim is there, lordship.
Interim will continue 19th of August.
CD is there, lordship.
Please, make please, Lordship. I become item 25. In this matter, the notice was issued to the informal Lordship. And on the last date, it was to take steps on the notices served on all matter. The claim will be taken up on Tuesday, so that amicus can be appointed also.
Okay, on Tuesday, POXO matter.
Yes, Lordship, he should custody more than.
You take in instruction item number
25, Lordship.
25. Tuesday.
Maybe it's, I don't know, 55, the case there is probably received also. There is a lapse on my part also. I failed to take step on the informant also. Yesterday, I took the step also. It's a POXO matter also.
So we have to wait.
Yes, Lordship.
Heard Mr. D. Das, learned counsel for the petitioner, who submits that the petitioner, due to why? Due to
Inadvertently, Lordship.
inadvertently failed to take steps for issuance of notice on the respondent number, for issuance of notice on respondent number 2 as directed by this court. However, he has taken the said steps day before yesterday.
Yesterday, Lordship.
List this matter again on 11th of August.
Lordship, there is an interim order that.
The interim order shall continue. 19th of August. 19th of August, interim order shall continue. You have to give that case diary where 7 matters.
Well, some.
Yeah, Parashar is there.